Okay, so hang tight, everybody. Should be just a moment. Okay. Terry, I see that the court is live, but are you going to pin everyone onto the top of the screen?
It's already pinned, Judge. You can start it.
Oh, they are? Oh, they're not for me. So, okay.
Not for me either.
Yeah, I don't know. They're not for me.
We're all over the place.
Yeah, we're not pinned. I mean, I can go and pin us to my own screen.
Okay, there's Judge Michael. And let's see if we can get, even just on the first page, the other two judges, so that we can all see each other as we are holding oral argument.
Judge is pinned. You can start it, Judge.
Okay, I'm going to start it. All right. Good afternoon and welcome to the Appellate Division First Department. Welcome to our live streaming. We have more than 7 hours of oral argument requested today, so I'm going to ask you two things. I'm going to ask you first to be patient because we have to do the clock manually, so that's going to take me a minute in between litigants. And also, I'm going to ask you to request oral argument time just for the time that you need, not the time that you want. We have lots of cases on. We've read all your briefs. We are very familiar with your arguments. And if the judges need more time, they will continue asking questions. Okay? So, number one, People versus Angelo Torres. Defendant? Okay, so that is submitted. Number two, Cheng versus Caban.
Good
Appellant?
afternoon. On behalf of the
okay.
appellant, Police Pension Fund, I request 3 minutes and 2 for rebuttal, please.
Okay, and for respondent, I'm sorry, respondent.
5 minutes, Your Honor.
All right, so I'm going to give
I'll
you
try to do it
3,
quicker.
2, and 4. W.A. Children.
Good afternoon, Justices. My name is Michael Weinstein, and I represent the respondent appellant, Miss A. I request 4 and 1, please.
Good afternoon. My name is Eva Jerome from the New York City Law Department representing ACS. I request 5 minutes, please.
Anyone else here? Okay, so 4, 1, and 5. Number 4, Payano versus Al-Nashal.
Good afternoon. Good afternoon, Richard Barber. On behalf of the appellant's defendants, we're requesting 8 and 3.
Good afternoon, Your Honor. Anthony DiStefano on behalf of plaintiff respondent, request 5, please.
5, 2, and 5. Number 5, Molina versus Opula Management. Appellant.
For the appellants, Bob Cosgrove from the law firm Wade Clark Mulcahy, I request 5 and 2.
Respondents.
Plaintiff respondent, Molina, 5.
2 and 5.
Plaintiff responded, Carlos Matias, 3 minutes.
Oh, I'm sorry. You're right. Okay. 5, 2, 5, and 3. Number 6 and number 7, which we're going to argue together. PH 105 Realty versus Allian. And on this case, let me say 2 things about this case. Number 1 is that Judge Michael is recused. And 2, I'm going to for purposes of making this the easiest, I'm going to hear this case last. So I know the attorneys are going to have to hang out with me for a while, but it's just easier to have Judge Michael exit at the end than try and move her in and out. So, appellant.
Just processing what you said, Your Honor. Go ahead.
Well,
So,
who's, Ayman Abushi I have is
Yep.
for the appellant.
Yep. I was gonna ask 5 and 3, Your Honor.
Okay, and respondent?
Good afternoon, James Smith, on behalf of, respondent and cross appellant. I request 10 minutes total, 5 for the response and 5 for our cross appeal.
And
Okay.
for the appellant on 7, 5 and 2.
I'll request 5.
Excuse me?
And for the other one, Your Honor, I'll request 5.
Okay, I'm gonna give you 5, 2, 5, 2, and 5, okay? People versus Jaquan Moore, appellant.
Good afternoon, Elizabeth Lagerfeld for Mr. Jaquan Moore, requesting 5 and 2, please.
Okay, respondent,
Jonathan Gold for the Office of the District Attorney, 5 minutes, Your Honor.
okay. Number 9, People versus Raul De Leon.
Good afternoon, Your Honor. Marielle Stein of the Legal Aid Society on behalf of Appellant Raul De Leon, requesting 5 and 2.
Okay, respondent,
Good afternoon, Your Honor. Joseph Tucker for the respondent. 3 minutes is fine, Your Honor.
okay, 5, 2, and 3. Cole versus Memorial Sloan Kettering, appellant.
That's you.
It's me.
Mr. Cole,
I'm here.
yes. Okay. How much time would you, let me ask first, is the respondent here?
Yes, respondent is here, Your Honor. Good
All right,
afternoon.
so, Mr. Cole, how much time would you like? Understanding that we are really giving very little amount of time.
The whole 15 minutes for my arguments.
I
Unless
understand that,
something
right.
is left, something if there are 2 minutes left.
Mr. Cole, I'm
So
not going to
then-
give you 15 minutes. Nobody's getting 15 today. Too many arguments, too much time. How about if I give you 5 minutes and 1 minute in reply, and I'm going to give the respondent 5 minutes, okay?
Thank you.
That's generally what I'm giving everyone.
Just
Number 11, AS Helios
They
LLC
gave
versus
you 5
Chahan.
minutes. Well, it's at 15 minutes. They don't.
Okay,
they don't-
Mr.
Please.
Cole, I need you to, right, okay, good, thank you. AS Helios LLC versus Chahan. Appellant. Mr. Tierney, no one? Okay, I'll mark it submitted. Number 12, West Point Home versus Dormify.
Good
Appellant?
afternoon, good afternoon, Your Honor. Appellant 5 and 2.
Okay, respondent.
Good afternoon, Your Honor. Ramshan Sari for respondents Quadrant Management, Inc. and Alan Quasha requesting 5 minutes.
Okay, is the
And
other
Your Honor,
response?
Yes, I'm sorry, Judge. Good afternoon. Scott Klein. I'm New York counsel for respondents Clarice Global Capital and Lisa Myers. I'd like to introduce Kelsey Cleary from the law firm Finn Dixon and Hurling, who's been admitted pro hoc vice in this case, Judge. And with the court's permission, we'd ask that she be able to argue this appeal.
Okay, welcome, Ms. Cleary. How much time would you like?
Thank you, Your Honor. I'd like 5 minutes, please.
Okay, I'm going to give you then 5, 2, 4, and 4. People versus Erica Yu.
Good afternoon again, Marielle Stein from the Legal Aid Society. Just 1 minute, Judge.
Okay, and respondent? Do we have a respondent? Maybe
No.
not. Okay, so 1 minute. Abrams versus Abrams, appellate,
Just 3 minutes, Your Honor.
respondent?
There isn't.
Right. Okay, so 3 minutes. People versus Ashley Wade.
Denise Fabiano, on behalf of Miss Wade, appellant, requesting 10 and 2.
And
Vince-
respondent,
Vincent Regalisi for the Bronx County District Attorney will request 10.
I think I'm going to give you 7, 2, and 7. Okay. Walker
Yes.
versus City of New York. Appellant.
For appellant cross respondent, request 4 and 2, Your Honor.
Okay, so, all right, so 4 and 2 on your appeal and
Respondent would request 5, Your Honor.
5 for, and including your cross appeal?
Yes.
Wait, whoever is speaking, gotta put yourself on mute, please, because I can't hear everyone else. So I'm sorry, say that again. You're saying
a total of
5 for
5.
your appeal and cross appeal? Okay.
Yes, Your
So
Honor.
4, 2, and 5.
Yes.
O'Flaherty versus Colombo, appellant. Okay, that's submitted. Rothman versus Rothman, appellant.
Nehemiah Glantz for defendant appellant 8 and 3.
Respondent.
Jason Steinberg from Harris Keenan, request 4 minutes.
I'm going to give you 6, 1, and 4. People versus Esteban Villaman Amante.
Appellant requests 4 and 1.
Respondent.
4 minutes, Your Honor.
4, 1, and 4. Number 20, May versus Gibbs is submitted. Okay, so for argument, let's go to our first Cheng versus Caban. Okay, give me a minute to just start my timer. And then, okay. Okay, counsel, are you ready?
Ready, Your Honor.
Yes, Your
Okay.
Honor.
All right, go ahead, counsel. You may begin.
May it please the court, Susan Paulson on behalf of the appellants, Police Pension Fund et al. And I just want to start by apologizing. The judges are not pinned on my screen. And if I don't catch a incoming question, my apologies in advance. Please interrupt.
So let me just tell you, let me interrupt and say to everyone that we sort of have informally agreed amongst us judges that we will start by saying, I want to ask a question. So if you hear that, you'll know that one of us, even if they're not pinned, is going to ask you a question, okay?
I think we can work with that.
Perfect.
right.
Thank you very much.
Okay,
May it
go
please the
ahead,
court.
counsel.
Your Honors, the Supreme Court erred here in annulling the Police Pension Fund's determination denying accident disability retirement benefits. The petitioner failed to satisfy his burden to establish that he was entitled to accident disability retirement, which I'll refer to as ADR, as a matter of law. The burden was on the applicant to establish that he was in city service at the time of his accident, and the Police Pension Fund split by a tie vote. And in order to set aside the denial of ADR by a tie vote, the record must establish as a matter of law that the disability was a natural and proximate result of a service-related accident. And if there's any credible evidence of a lack of causation, the determination of the Board of Trustees must be upheld.
So let me ask you let me ask you a question. What is the credible evidence that you are citing in the record that would help to sustain the denial of ADR benefits? What
Yes, Your
evidence
Honor.
is there?
Yes, Your Honor. It's 3 pieces of undisputed evidence, which is the fact that the accident occurred an hour before the petitioner's tour of duty was to begin. That's on the record at page 47. The second piece of evidence is that at the scene of the accident, the petitioner did not report that he was responding to a crime of progress, and that's the accident report, which is in the record at 62 to 66. And the third piece of evidence is the line of duty injury report that he submitted the day after the accident that checked off the on-duty box, but did not identify any assignment or explain that he was responding to a scene. Those three undisputed pieces of evidence are credible evidence of lack of causation. Now, on top of those pieces of undisputed evidence, the timing and sequencing of the additional evidence that the petitioner produced over the course of 3 hearings of the Board of Trustees further caused 6 of the 12 members of the Board of Trustees to have doubt as to whether or not, and to conclude that the petitioner was not in city service.
So
And that
am I,
timing-
may I ask a question? So am I
Yes.
correct that it took close to 2 months for the petitioner to come to amend the report to talk about why he thought he was in city service at the time?
That is correct, Your Honor. 7 weeks after filing his line of duty, he sought to amend it to introduce the information that he was responding to a crime in progress at the time of the accident. That was the information that was before the Board of Trustees. And it wasn't until 2 years after the accident, when the Board of Trustees had concerns, that he then produced the duty log indicating that he had called in to report for duty by quote unquote outside wire when he had heard the dispatch report of the crime in progress. And then it wasn't until a month after that that he subsequently introduced a statement by the desk surgeon who had made that entry into the duty log.
Okay, counsel, your time is up. I'm going to ask the respondent to start.
So, Your Honor, counsel is correct that this entire case boils down to whether my client was in city service at the time he suffered his disabling accident. Nobody disputes that he had an accident that caused an injury that was disabling. Nobody disputes that it was caused by the injury in question. This is all conceded. The only question is whether he was present for duty officially when he got hurt.
I have a question. Counsel, how are we to view the delay in producing proof or evidence that he was on duty? I mean, there was a significant delay. How do we view that?
We addressed that very thoroughly in the brief, Judge. He was being treated for his medical injuries. He hadn't filled out his own line of duty report because nobody does. His supervisor did. He didn't know what was in the report, had no idea it had any deficiencies of any kind, until he was forced to come in and review the report when he finally came back to, I guess, restricted duty. When he saw it, the second he saw it, he said, oh, I have to make a change. I have to make sure that they know about this. So he did an amendment. He let them know about it. And that was that. There's no dispute whether he was calling in from an outside wire. There's no dispute as to whether the desk sergeant correctly noted that he had done so before his tour began, as he always does. He had, out of his last 11 starts at that tour, 9 of them he called in early for duty. This was his part of his pattern and practice. He did it all the time. It was encouraged. The only thing that the city has to even argue against this is one trustee who thought, and it's in the brief, who said he felt it was odd that a captain reported to a grand larceny in progress. Well, this was not a police officer who said this. This is not someone affiliated with the NYPD.
I'm going to ask you a question. That's not really it, right? He didn't tell the officer who responded to the car accident that he got into, I'm on the job, I'm on duty, said nothing to anyone whatsoever. So it's
But Judge, that would be
so
perfectly
there are
normal.
so that's a circumstance that the board is entitled to take a look at and to make findings on.
Yes, Your Honor, I agree with that. However, the import that they placed on this mere suspicion, which is not credible evidence, this is doubt, which they had every obligation to investigate under the matter of Brady, which is a Court of Appeals case. If they have suspicions, they can't act on suspicions. They need to investigate their suspicions. And they had every ability to do this. They could have called over to the NYPD very easily and
Counsel,
said,
I have a question.
what are your
Counsel, I
current
have a
practice?
question. This is Judge
Sure.
Michael. I have a question.
Yes, Judge.
In terms of the other officers' paperwork substantiating that your client was on his way to work, do we have any real proof of that? I mean, because from what I recall of the record, she didn't recall what happened that day, the officer that he called into.
Nor would it be normal for her to remember anything that happened months in the past that she made a simple entry on. She simply was able to confirm, this is my handwriting, I wrote this, and on that date. There is no contradictory evidence, no
What
documentary
about
evidence,
this,
no
counsel?
witness
What
testimony.
deference, counsel, what deference was the court to give to the board's determination?
On issues of causation, very little. Article 78, by its very existence, implies that judges can oversee and overturn these determinations if they're improper. Here, no credible evidence supported their determination, as is required under a tie vote under Canfora. If there's a tie vote, then there must be credible evidence in order to determine whether this person, whether there was a line of duty incident here or not. And that line of duty incident, by the way, is not determined by the Board of Trustees. It's determined by his supervisor, and no one has ever questioned that either. Nor did they question his supervisor, nor did they question the sergeant who wrote what she wrote about having written the entry in the command log, nor did they dispute that the command log entry was legitimate and there. That is
Okay,
the Bible
counsel.
of the precinct.
All right.
Under every
Let's go
stitch
back.
of evidence in the
Counsel,
case.
your time has ended. And let's go back to the appellant or I'm sorry. Yeah. I think you reserved 2 minutes for rebuttal.
Yes, Your Honor.
Go ahead.
Thank you. Just a few quick points. One is that it was not just one trustee that had doubts. It was 6 trustees. 6 of the trustees were persuaded by the command log entry that the petitioner was in city service at the time of the accident, and 6 of the city trustees were not. In addition, I'd like to point out that the trustees did not have an obligation to investigate. The burden is on the petitioner to establish that he was in city service at the time of the accident. They adjourned 3
Counsel, let me ask you a
times.
question.
Yes,
So
Your
what you're
Honor.
saying is we put in this, here's this evidence. It's circumstantial, as is much evidence, but we get to draw conclusions from the circumstantial evidence. And so the question then becomes whether it's okay to use circumstantial evidence to base a 6-6 tie and say no ADR, or which is a different thing from saying there is no evidence.
Sure, Your Honor. This would be a different case if we didn't have the accident report not saying he was responding, didn't have the fact that it was before his tour started, and didn't have the line of duty not indicating he was responding. If it was only based upon the timing and sequencing of evidence, then this would be a different case. But here we have 3 pieces of undisputed evidence that would, if the command log had never been introduced, would have established that he was not in city service. He subsequently produced evidence that did support an inference or a conclusion that he was in city service. But there was evidence on both sides of the ledger, and the Board of Trustees carefully considered it. 6 of them were persuaded, 6 of them were not. And on this record, it cannot be established as a matter of law that he was in city service. We're not asking this court to reweigh the evidence, and it was improper for Supreme Court to reweigh the evidence. On this
I have
record,
a question, it's Judge Hagler.
yes.
The captain stated that he was it was a crime in progress, and that he was going to a grand order of larceny. Would it be what evidence did he put in that a rather low level of crime would be attended to by the captain of the precinct?
Yes, Your Honor. There was no evidence introduced. His attorney at the trustees meeting argued that this was a hot topic in the precinct, and therefore he was responding. There was no affidavit or supporting information that he chose to introduce from anybody else in the precinct, either explaining that grand larceny order was of importance to that precinct, or explaining that it was routine for captains to respond to crimes of this nature.
Okay, thank you, counsel. Thank you both.
Thank you very much.
Number 3, WA Children. Appellant.
Just
Ready?
let me know when to begin, Justice. Yes.
Right now.
Good afternoon, Justices, and may it please the court. My name is Michael Weinstein. I represent the respondent appellant, Miss A. And certainly if I'd known we'd be virtual when I practiced before 5 snow justices yesterday, I would have put the camera in front of them. This court is being asked to apply the limits that the Court of Appeals applied 22 years ago in Nicholson versus Capetta concerning imminent danger. We have a proceeding where the family court held that all the evidence and all the witnesses were credible in their testimony. And when you look at the record in its totality, it doesn't reflect the imminent danger that Nicholson suggests is necessary. We have a finding that there was neglect by virtue of mental health. But here, the nexus, which is a requirement to make a mental health neglect finding, is that Miss A called the State Central Register seeking respite care. This respite care is something that not only had ACS offered Miss A to help her, but further is something that is actually mandated as part of mandated preventive services from our statutes. The family court inappropriately took that request, a valid legal request, something that the state was in fact obligated to provide, and held that that was the nexus for a neglect finding here. And although there
I have a
are,
question.
please, Justice.
Inside the family court's order, the judge makes reference to the fact that the mother testified or indicated that she didn't want the children. Was that reflected in the record?
No, Justice. There are actually three statements in the record concerning that. Initially, there is a statement that appears to imply that from the call to the State Central Register. But when Ms. Arrington testified, she stated that she needed a break, that she was overwhelmed at the moment. It was a very difficult day on July 2nd, 2023, when that call was made. Her daughter suffers from autism, and her two younger sons were acting up, and that's no reflection on any diagnosis or their behavior. And it was just a very difficult day for her, and she was overwhelmed.
And in fact, one could argue that the reason for this respite care, the reason why it's even available, would be for circumstances such as this.
Without a doubt, Justice Pitberg. In fact, if you look at the regulations related to the statute that requires this preventive services, the examples are precisely what happened here. If a parent is overwhelmed and needs a break, it's an actual example within the regulations, then it's to be provided as part of the mandated preventive services.
Counsel, I have a question. This is Justice Michael. One of the issues that came up in the record was a burn that one of the children had on their hand. Was that a part of the court's calculus in terms of finding neglect?
The burn, Justice, is not mentioned once in the court's either oral order during the trial or in its written order. And if we think about what it would take for that burn to make a finding, of course, independent of it being mentioned in the order, it would require that Miss A failed to provide a minimum degree of care. But in holding her credible, the court accepted that Miss A went to urgent care, had the burn treated, and followed up with the recommendation, which was to make an appointment with another physician. Unfortunately, Miss A couldn't go to that appointment because by the time that appointment came up, a week later, the children had already been removed from her care. And so the court does not refer to it.
I have a question. When the children were removed, what was the legal authority to do so? Because I know that they hadn't gone into family court yet, right?
That's correct. And I guess just for precision, the youngest child, the child with the burn, was at the home with Miss A. The other two children, on agreement with ACS prior to any removal, were with a family relative. When Miss A went for the authority is Section 1024 of the Family Court Act, which actually requires that a petition is filed the next court day. Now, of course, the removal occurred on July 3rd, 2023, and July 4th is our national holiday. But that petition should have been filed on the 5th. So at the time when the petition was filed, the state had already delayed several days. And when asked during the trial why this had occurred, they said because they wanted to hold the child safety conference first.
Okay, counsel, your time is up. Oh, I'm sorry, Judge Hagler, did you want to ask a question?
Yeah, just one quick question. Just want to make sure that the burn, there's no one arguing that was an accident. No one saying that there was neglect because of that issue.
I mean, it seems just in reading petitioner or respondent's brief that they do argue that. But when you look at the medical records which are in the evidence, the medical records indicate that the burn was healing properly. There's no indication that there's any maltreatment concerning the healing of that wound.
So I actually want to know how it occurred. I'm talking about the actual burn, not the treatment.
So the court accepted the credibility of Ms. A's statements that it was an accident. She was ironing a shirt for one of the children, and the child, who was very young, a toddler, jumped up and unfortunately caught the iron.
Thank you.
Okay.
All right, thank
All
you,
right, thanks.
Justices.
Okay, respondent?
Yes, good afternoon. Eva Jerome from the New York City Law Department. May it please the court. The mother's mental illness and lack of insight led her to refuse or discontinue multiple offered services, treatment, and assistance, ultimately causing a mental health crisis that placed the children at imminent risk of.
I have a question. This is Justice Pittsburgh. So the way that this, it's my understanding that the mother called for this respite care, correct?
No, Your Honor, that she called to give up her children and she wanted ACS to take them. She was relinquishing them.
Well, this is Justice Michael. My understanding is that she called seeking help for a period of time. That to me equates to respite care.
She said in the ORT, she said, I no longer want the children. I want ACS to take them. And when she was at fact finding, her initial response to whether or not she said, oh, you do want them taken away was, I don't remember. It was only later then that she said, that she claimed that it was only a temporary thing.
I thought that the narrative, this is Justice Pittsburgh, I have a question, that the narrative of the ORT stated that she was feeling overwhelmed with caring for the children. Was she not overwhelmed? Or is that?
She was more than overwhelmed. She was placing her children at imminent risk of harm by asking for ACS to come take them. And she said, I no longer want the children. I want ACS to take them.
So let me make sure I understand you correctly. Mom who calls and requests respite care is placing their child in imminent harm. That is a basis for a neglect finding because you've reached out to the entity that you're supposed to reach out to for help?
Your Honor, we think that the record supports the fact that it wasn't respite care that she was asking for. That's the key, that she was asking for permanent, having them taken away. And
and that's not based on anybody who had the phone call with her. This is Justice Scarpula, right? That's just, there's a note that says, I'm overwhelmed. I need you to take these children. And your interpretation of that is, I don't want them forevermore anymore. And her interpretation, as she testified at trial, was, I needed a break from them. That's what I was saying. And she's the only one who is in the conversation. And the only other thing that you have are notes, right? So there should be no disbelief of what she's testifying to, because actually what she's testifying to is entirely consistent with the notes. Second, she has a psychiatrist, correct? And the court credited that. It's not that she has untreated mental illness that she's doing nothing for, correct?
Your Honor, she stopped therapy abruptly 3 months before making the call and spiraled into a crisis.
Because she felt that the psychiatrist wasn't a good fit. Is that right? And all that testimony was credited. No one said you're not telling the truth. That's what was happening. She was taking medication. She went off one medication because of the side effects. She didn't feel like it was a fit. Then she seeks help and says, I am overwhelmed. I do not want these children right now, or I don't want these children. And later she testifies what she meant was, I can't deal with them now. And there's nothing to dispute that testimony. And that's what you're saying the finding of neglect should be on.
Your Honor, yes, she first,
okay.
during fact finding was when she said, I don't remember what I said, and then said, yes, it was only for temporary. So I don't know if I said yes to something that is an admission. I was agreeing that we're basing it on on her request for a permanent removal of the children. And
although it doesn't say permanent in the notes, and she testified that she didn't intend it that way.
Your Honor, the family court was entitled to discredit her, and the family court made an important note about her affect during her fact-finding testimony.
But later, but it appears that when she at the second hearing that her affect was different, and the court noted that. So it seemed that did not accept her testimony, that she said, I may have been feeling overwhelmed, but now I really need a little respite. And I don't want the children taken all the time. So it was sort of a selective acceptance of testimony.
Your Honor, I respectfully disagree. I believe that the family court said that it did not credit her denial of saying that she was going to harm them, that she felt like she was going to harm them. She had asked for, and you have to take into account the fact that ACS receives the ORT, it goes to investigate, and it sees this horrific burn on the child's arm. He's only 2.5. And this moment in the days before, she did not.
Wait a second, counsel. When you say horrific, where is that coming from?
Well,
is there any document that says it's a horrific burn?
No, that is.
So it's a burn, right? Plenty of
that-
burns are not horrific burns. All right. In any event, your time is up. Thank you, counsel.
Thank you.
And petitioner, you have, appellant, you have one more moment.
Thank you, Justice. So I just want to clarify just one statement based off a question you asked Justice Scarpula. Miss A actually was still seeing her psychiatrist. It was her talk therapist that wasn't a good fit, and then she was waiting for a new therapist to be assigned. I'd also want to address what my esteemed colleague said regarding refusing services. Within the record itself, there's no indication of any refusal. There's a mention in ACS's brief concerning daycare that was denied, but in fact, if you look at the transcript as cited by my colleague, it's very clear that there is no remark that that service was denied. There's no indication about its implementation, but it says that she was provided with it. The real issue with services surrounds the preventive care and the providing of it. There seems to have been, as best as I can tell from the record, a misunderstanding initially with ACS concerning Ms. A's willingness to engage with preventive services. And she's asserted that she was always willing. And that was clarified finally at the Child Safety Conference, at which time, rather than filing a petition based on the regulations, ACS could have and should have provided whatever services, including the preventive services and respite care that comes with that, to Ms. A.
Okay. Thank you very much, counsel. Thank you, counsel.
Thank you, Justices.
Payano versus Al-Nashal.
Good afternoon, Your Honor. Richard Barber for the appellant's defendants.
Okay, go ahead.
All right. We are appealing the December 2024 order of the lower court granting the plaintiff's summary judgment as to liability, as we contend that the decision was based on inadmissible evidence. At the very least, and when viewing the facts in the light most favorable to my clients as a non-moving party, questions of fact regarding the reasonableness of my client, Mr. Nishal's conduct exist that warrant reversal of the lower court's order. Now, with respect to the unauthenticated police report, which is one of the documents upon which the respondent relied in the underlying motion for summary judgment, respondent explicitly argues at page 2 of his opposition that, quote, the report is evidence that the accident occurred in the crosswalk, close quote. However, that police report is unauthenticated and inadmissible for purposes of deciding summary judgment. And even if it was authenticated, it doesn't place the decedent in the crosswalk at the time of the accident. Rather, it places the decedent, quote, in the vicinity of an intersection. It's not entirely clear what the officer meant here by writing vicinity. That could certainly encompass areas within a crosswalk, or it can encompass areas outside of a marked crosswalk. Because the officer was never deposed, and that speaks to the prematurity by which liability was determined here. We just don't know what he meant when he used that term. The respondent's argument that the diagram that is included in that police report shows that the decedent was in the crosswalk and is based on the officer's own observations is similarly baseless. The plaintiff cites to 2 cases, Wynn and Juergens, which actually stand for the principle that a diagram in a police report that is not based on that officer's own observations is inadmissible.
Just to follow up with what you're saying, obviously the police officer got there after the accident. They weren't standing there waiting for the accident to happen. So, you know, we get that this was drawn or put in there, listening to testimony from other people, but that the officer did not see it.
Right, but yes, I agree, Your Honor. And I think that the point here that I'm attempting to drive home is that We're not sure what the diagram is intended to show because, again, we never deposed the officer. We don't know what he's intending to depict. Is it intended to be to scale? Why are there no crosswalks in that diagram, et cetera, et cetera? Both respondent and the court assumed that the police report was based on the officer's own observations, but we have no idea because that officer was never deposed. In addition to that police report, the respondent relied on Google Map imagery and some medical records to argue that the decedent was stuck in a crosswalk. Quickly, with respect to the Google Map, it shows a crosswalk, but it also shows area of the road that are outside of the crosswalk, and certainly doesn't place the decedent anywhere on that image. Simply because a crosswalk exists doesn't mean that the decedent was walking within it at the time the accident occurred. With respect to the medical records that the respondent relied upon, those are the ambulance and the autopsy report. They simply indicate that the decedent was struck by a vehicle and died of blunt force trauma. It doesn't place the decedent in a crosswalk or otherwise reference a crosswalk in any way. There is actually no admissible evidence that places the decedent in a crosswalk prior to, during, or immediately after the accident occurred. We respectfully submit that when viewing the evidence in the light most favorable to my clients, the evidence demonstrates that Mr. Nishal looked in all directions before making the turn, and only after beginning to make that turn did he hear a bang behind him at the rear of his vehicle. And when he stopped, he saw the decedent on the ground outside of the crosswalk.
So a question, it seems that the court discounted Mr. Nishal's testimony as incredible. Is that correct?
That is correct. And, with respect to the content of my client, it's not clear if they were deeming my client's deposition testimony or the affidavit that was submitted in connection with the motion for summary judgment incredible. I thought it was the latter, the affidavit. But, it's important to note that regardless of what they're actually referring to, the deposition testimony and the sworn statements in that affidavit are completely consistent and complement each other. The affidavit was intended to address issues that were not addressed by the respondent's counsel when they were deposing Mr. Nishal. And there was nothing incredible about the contents of that affidavit when considering that it does not contradict any sworn deposition testimony or other admissible evidence. Although Mr. Nishal never places the decedent within that marked crosswalk at any time pre or post accident, neither does any other piece of admissible evidence at this point. And one of the cases that was cited by the court for claiming that this was incredible was the Kirschgesner case, 40 AD 3D 437. It's a First Department case in 2007. And in that case, they deemed that the defendant's statement that he never saw the decedent while also being observant was incredible in light of deposition testimony from eyewitnesses and police. Hello?
That's just the alarm going off telling you it's
Okay.
your time to wrap it up.
I am wrapped
Okay,
up. Thank you.
Let me let respondents speak. I'm sorry, Judge Hagel, you had a
Yeah,
question.
I have a question. To be fair to the trial judge, I thought what he said was what was incredible was that the theory of the driver was that the decedent went into the truck. I think that's what was incredible, if I read the testimony correctly.
Well, my interpretation was that, it's incredible when considering the other evidence out there of which there is none. And they cited to that Kirschgesner case which specifically includes uncontradicted eyewitness deposition testimony and police evidence establishing that the plaintiff's decedent was crossing within a properly marked crosswalk. So for the defendant in that case to say, no way, I was observing him the whole time, I saw nothing, that's incredible. We don't have that situation here. Thank you, Your Honor.
Okay, thank you. All right, respondent.
Good afternoon, Your Honors. May it please the court, Anthony DiStefano for the plaintiff respondent. There's more than just the crosswalk at issue here, though. There are two standards that govern liability in this case. It's not just the crosswalk. It's also the failure to see what was there to be seen. And he cannot get around the fact, the defendant, Nishal, cannot get around the fact that he freely admits he didn't see anything.
I have a question. This is Justice Pittsburgh. This was your motion for summary judgment on liability. Is that correct?
Yes, Your Honor.
Right. So let's start there before we get to defendant. And I noticed that a lot of the cases that you rely on had admissible evidence to support their position in their motion. Shin, Diaz, Martinez, all coming out of this court after 2020. So I'm just wondering if you could just maybe point in your motion papers, your argument what did you have in terms of admissible evidence that would support your position?
So it begins with Nishal's testimony, as I just indicated, that he does not see, even though he claims to be observant, my client in the
Right, but we know
roadway.
that you can't just point to defects in, like, let's say the testimony. Let's talk about your evidence outside of that.
Okay, if we talk about my evidence outside of that, Your Honor, then what we have is a certified FDNY report, which indicates that there were tire marks on Mr. Payano's abdomen when he was found at the scene. There's also in the report is included that he was found underneath the vehicle, which means that the vehicle had run over him clearly because number one, he had tire marks, and number two, he was found underneath the vehicle.
Counsel,
So
I
He
have a
was
question.
found,
Oh,
yeah,
sorry.
go ahead, Judge Hagler. No, you go ahead.
Did you have an expert describe that as a result of all that, the defendant caused the accident? Don't you have to have someone, actually, the dots have to be put in order, and you haven't done that?
Judge, I do not see a need for an expert in a situation where the jury, if ultimately this went to a jury, they could clearly see from the evidence that's being presented to
But
them
that's
how
the
the accident
inference.
occurred.
I understand you have an inference, but where is your proof conclusively that as a result of defendant's actions, the plaintiff was unfortunately killed?
Just for clarity, Your Honor, you're talking about the link between the impact and his death, or are you talking about the
No,
actual
I'm
impact
talking about
occurring?
liability. How do we know it was the fault of the driver when there's no one testifying to that and we have no expert? That's my point.
But under Noseworthy,
You're
we would
looking
be
at
allowed.
gaps in the evidence, as my colleague said. I understand that you can have inferences from the defendant's testimony, but how do you fulfill your own burden?
No, but the inferences drawn from the testimony in conjunction with the FDNY report, which is, there's no dispute, is an admissible document, correct? Along with what we argued was that the police report that is based on the officer's observations, the diagram is specifically
Now, are you
the truck.
disputing, counsel? Let me interject just a second and saying that's not an admissible document. It's not certified. You didn't have the police officer come in. It's not admissible. Are you arguing that it is?
I'm arguing that where an officer's observations, and
So
this
let
is
me
this court's.
ask you again, are you arguing because the officer didn't testify and what you have is the police report? Are you arguing that the police report is admissible evidence or is it not admissible?
I am arguing that it is admissible, Judge. The case is Bomick,
For what and
B-H-O-W.
how? How did it become admissible?
And I'm about to read to you, Your Honor. This is this court's decision from 2016. It's 140 AD 3rd 460. Quote, the police accident report in which the officer recorded his own observations that plaintiff smelled of alcohol and appeared to be intoxicated was admissible. So that's
Yes,
my argument, Judge.
Okay,
in
counsel.
this, I was gonna say, but in this case, it wasn't really his own observations. I mean, he came afterwards and put together a report, but he didn't have any observations. I can understand his observations, that's different.
I'm saying, Judge, that he observed my client underneath the truck in the roadway behind the front tire of the vehicle. That's what I'm saying. That diagram is a depiction of that officer's observations of what he saw. It's not what he claimed that he understood to have happened. Instead, it's his physical observations of what
But
he saw.
counsel, that's not his observation as to the actual accident. That's his observation as to what the aftermath looked like. So we can't use that as admissible evidence for the happening of the accident.
But again, going back to there's more than one theory of liability here. It's not just whether this was in the crosswalk or not. It is also that it happened in a roadway where a driver who under the VTL fails to see what he should have seen is negligent in causing an accident. And that's the
So
argument
then,
is that.
I mean, counsel, if we were to accept what you're saying, anytime someone is struck by a car, then there would be liability on that driver. And clearly that's not our law. We have to look beyond that. And so when we're looking beyond that, we're going to look at what it is that you have to support that. At summary judgment, you have a certain burden. And I'm not sure that you've explained to us or that the papers support that burden.
Respectfully, Judge, my client was killed in this accident. The defendant driver has testified, I don't know, I didn't see him. Did he touch the vehicle? Did he not touch the vehicle? Goes back and forth on all of this. His version of this accident is simply incredible. And that's
So,
what
but
this
I
court
mean,
found in Martinez.
Again, that's what we're talking about. We can't make that determination
Yeah.
about whether
But
something's
this court did in
incredible or not.
Martinez, so
That
I don't.
is that is, one second, I understand, but that is really a jury issue, you know? And also, you have to show that your client had the right of way. There's nothing in the record that says whether or not he was traveling with a green light. I mean, there's a lot of things that aren't there.
Because my client is dead, Your Honor. He literally
I
crushed him with his
understand, but
truck.
there are other ways to prove that. And we understand the seriousness of the accident. No one is disputing that. The only question is, do you get a jury or is it a matter of law? That's it. All right. Thanks, counsel. And appellant, you have what do you have? 2 minutes. Yes.
I'll be less than that, Your Honor. Thank you. I would just say, as Your Honor's previously identified, that all of the cases that the plaintiff cites in support of their argument includes actual admissible evidence placing a plaintiff or a decedent in a crosswalk. We don't have that here. I did refer to 2 cases in my papers, Villaverde versus Santiago Aponte, 84 AD 3D 506, and Wine versus Robinson, 92 AD 3D 578, both from the First Department in 2011 and 2012, respectfully, where the courts reversed summary judgment in favor of the plaintiff, finding that there were questions of fact as to the location of the plaintiff or the decedent in those cases, and that's exactly what we have here, Your Honor. Thank you.
Okay. Thank you both. Number 5, Molina versus Apula Management. Appellant.
Good afternoon, Bob Cosgrove for the defendant appellant. The issue before the court is the scope of a landlord's duty when intra-tenant crime occurs. In the case before the court, the trial court erred when it held that the landlord and the property manager had a duty to prevent Albert Blees from committing crimes against the other tenants in the building. The relevant facts in this case are on March 6, 2020, Albert Blees, who had stored gasoline in his apartment, and no one alleges that the gasoline stored in his apartment violated the tenancy, statute, ordinance, or anything else like that. There's nothing in the record to support that claim.
Counsel, I think the issue, though, with regard to the claim is that this is a person who had been making threats to other individuals in the building, physical, violent threats, which this person, some of the plaintiffs contend were passed on to the building management. And then on top of that, he's carrying in gasoline cans, and not just cans, but large gasoline containers into his apartment, and the building does nothing.
Because I think the first thing to note there is there's no evidence in the record, none whatsoever, that there's a specific threat by Mr. Blees to have alleged to have burned the building down or otherwise to commit an arson. The threats that Mr. Blees is alleged to have made in the past, most of which are specific to Mr. Pizarro, focus on a knife attack, where he had a knife knocked on the door and made some threatening sounds, and then generalized statements about killing people. There's no specific threat in this building, no specific threat in the record that suggests that the landlord or the building property manager.
I have a question. I thought it was more than that. I thought that there was a direct quote that he's going to blow up the building. It wasn't a fire, but there was a specific threat that he's going to kill everyone in the building.
Judge, respectfully, that's not in the record. In the record, if you go to page 1140 of the record.
Look at 1151 to 1152.
Yes, Judge, there are 2 sections in this, and they're inconsistent in respect of that. The 1140 as opposed to the 1150, 1151 talk about the back and forth where Mr. Pizarro was pressed as to whether or not he specifically heard Mr. Blees say he was going to blow the building up. And he backed off from that statement and said, in fact, he heard other people in the building make statements like that. And he had no specific recollection of Mr. Blees specifically saying that he was going to blow the building up. There's no specific evidence in the record. If you look at the exact transcript quotes, that is not in the record. there's this generalized threat in respect of that Mr. Blease is alleged to have made, and no one disputes he made this threat. That's not in dispute. Mr. Blease is by all accounts not a good individual.
So my question is, we have this in the record. What is the landlord's responsibility? What is the standard by which we are to evaluate what the landlord's situation? I mean, I might not like that if that was in my building, but what can the landlord do? What's the standard that you think is established here in the first department?
I think it's the authority, ability, and opportunity standard, which the trial court rightly cited, and then dismissed by distinguishing it by saying that in the context of this case, because it was a generalized threat against the entire building and not a specific intra-tenant threat where tenant A said, for example, you made my daughter pregnant, I'm going to attack you now and shoot you, like some of the other cases that are out there, that somehow made this case different and distinguishable. And there's no support.
I just want to interject here because I think this calls back to Justice Michael's point about the gasoline cans coming into the building. Was there any evidence that the building had knowledge of that? Were they ever notified about that?
Judge, I don't think it matters, respectfully, whether he knew or didn't know about gasoline in the building, because there's no argument in the record that the tenant was not allowed to have gasoline in his apartment. That's not alleged. There's no expert in this case saying that gasoline containers in your apartment violate statute or violates ordinance or violates the lease even. So the fact that a tenant in the property, in the privacy of his own apartment, wanted to have gasoline containers is something he's allowed to do under the law. The landlord does not have a duty to figure out what the tenant's going to do with the gasoline. Maybe it's for model airplanes. Maybe it's for model cars. Maybe it's for criminal activities. The fact is the landlord doesn't have an obligation to go out there and try to figure out every tenant's intent in New York City anytime anybody makes a threat to one of their tenants, the neighbors, the community as a whole. That's putting upon the landlord a burden that's far too far and a duty that's far too expansive. Putting aside the foreseeability issue in the case, which is a real issue in this case, the duty that the trial court has placed upon landlords in the context of cases like this is quite expansive, because now the landlord has to go out and assess the mental capacity of anybody in the building who makes any kind of threat at any point in time and decide whether the landlord believes it's credible. That's
And
when the
counsel,
landlord effectively.
can I just ask you, does it make any difference whether there's been testimony that the police were called 30 or 40 times to the building for complaints by the tenants for things? I mean, does that change the equation, the standard at all?
I'll note two things. One, there's no evidence the police were called to deal with gasoline in the apartment. There's no evidence in the record of that. And two, the mere allegation that someone was accused with a crime or even stopped for a crime doesn't mean the person actually committed a crime. And again, if it's not good enough for the police in the context of a criminal prosecution, it certainly shouldn't be a burden placed upon a landlord to take over the role of the police, have to go out and determine whether or not a crime is about to occur or is imminent or anything else like that. The police called, they made no arrest. This person was not charged with a crime. And even if he was charged with a crime, he still has the right to live in an apartment building. Whether I like it or not, that's the reality of New York City. You are allowed to live in an apartment building and not be evicted just because people think you may be likely to commit a crime. That's not a proper duty to place on a landlord.
Counsel. Yes, all right. Respondent?
Yes, Scott Singer for the respondents, Pizarro and Molina.
Counsel, can we agree that we're starting out with the legal standard of authority, ability, and opportunity, which applies to tenant-on-tenant interactions, as opposed to a burger situation where it's a third party?
No, it's not, and it's never been applied by this court at all, and it's certainly never been applied to an arson case. As the Supreme Court recognized, this was a danger to everybody in the building.
Wait, are you saying that this court has never applied the ability, authority, and opportunity standard?
No,
or did I misunderstand you?
They never
We
have.
haven't?
No, it's a second and fourth department rule. That particular standard has never been applied. And I don't, as far as I know, no court has ever applied it to an arson case. But there's something I want to point out that my adversary didn't explicitly state. Defendants moved for summary judgment dismissing plaintiff's negligence claim in its entirety. When the motion was denied, they appealed from each and every part of that order. But in their briefs, defendants clearly acknowledge that they are not entitled to summary judgment. In particular, at page
Well,
12.
counsel,
Well-
let me interrupt you. They are
Yes.
saying, we're not going to fight you about the issue about the
Whether keeping the property and property.
the
and
property
proper
in good
maintenance,
shape, but
maintaining the
they
property
have
in other
made it
ways.
clear that they are fighting you on this issue, that the landlord should have the responsibility to police tenant against tenant issues. And we have never said that. We have never, ever, not only the second department nor the fourth department, but the first department has not said that the landlord should take action against, from one tenant with respect to protecting the building against a tenant. You know, that
It's
we've
not-
never said that.
It's not one tenant. There were more than one tenants who were affected by this. There were complaints, more than one
Oh,
made
I agree,
complaints.
but
And
the landlord has no responsibility. What if the tenant was mentally ill? What you're saying is the landlord would have a responsibility to make sure that they kicked out a mentally ill tenant because that tenant might have there might have said things to other tenants in the building. We have those situations all the
No.
time. We've never said the landlord has. What about a tenant that brings in an e-bike with a
When those
a
batteries.
battery that you know, we've never required the landlord to do that kind of policing. What the landlord is responsible for, I think, and this landlord is not fighting, is you have to have a safe quarters, you have to have alarms, you have to have water, all of that. I don't think they're disputing that part of the appeal.
that's correct. But I think that in this situation where there were multiple, at least there was testimony, there were multiple times when police were called because of this individual. He was screaming, he was loud.
What do you
he was
think the
deranged.
landlord's obligation was?
The landlord's
kick him out?
obligation is, no.
To kick him out?
Well, first of all, the landlord's obligation, as you acknowledge, Justice Scarpella, is to make sure that the building was safe in the event that there was a fire situation.
No, the building. You're saying we're talking about a tenant. What do you think the landlord's obligation was with respect to that tenant?
They could have at least investigated and questioned the tenant about what he was doing, bringing tanks of gasoline into his apartment.
Under what,
so
but under what theory do they have, I mean, under what legal theory do they have the right to do that? I mean, I understand your concern and in hindsight with what happened in this building, but under what, under what law, under what statute, under what theory can we require the landlord to do this, is what I'm trying to grapple with.
There's not, I mean, they could have investigated, they could have asked people about what was going on. They did none of that. They could have reported his conduct to the police.
Right, but the question is
It was
under what
verified.
theory of liability, counsel?
The theory is if it was foreseeable that an arson was imminent, and in this case, any sentient person would recognize there was a grave danger of arson. by
Even though
virtue of
there were no
the gentleman's
complaints
conduct.
about previous fires or anything relating to arson, there were no complaints relating to arson.
There were complaints that he was a violent person. He was a nuisance. And by the way, they could have evicted him simply because he was constantly making noise. All of that is, I'm not.
You do
purporting to
concede, though, that the ability to evict does not also create give the landlord authority and control over a tenant, right? Because we have case law to that effect.
No, it doesn't give him authority to control directly over a tenant. If he
Okay.
violates the rules, and in this case he did, because he was continually made a nuisance of himself and was frightening people, then they do have a right to evict him. But I'm
Yeah,
not
but
saying
that's
that-
not, but that's a different, that they don't have an obligation to do it. That's the problem. You're arguing that they must have. And with respect to if they saw him, anybody in the building could have called the police if they saw him walking in with some gasoline. But you're putting that obligation on the landlord as opposed to anyone else in the building, which I don't see. Anyway,
Well-
let's get back. We have
Carlos Matias, also
But,
plaintiff
yeah.
respondent.
yes.
So I just want to reiterate that my client lived on the third floor. Okay, so it was clearly not a tenant on tenant issue. he was you know, he never had a dispute with this person. In terms of foreseeability, I just want to build on what was just being discussed with Mr. Singer. You know, the building had knowledge that there was gasoline allegedly in that unit, and we're not talking about like a little canister of gasoline. I mean, the testimony was shopping carts full of gasoline. I mean, if you have
So what?
someone.
What the council, again, so what? The landlord might have knowledge that the one tenant is a convicted something and then but the landlord doesn't have an obligation not to rent or to kick out that tenant. What do you think the scope of the obligation is? What do you think the landlord had the obligation to do?
So not necessarily evict him, but I mean, the landlord has a obligation to the rest of the tenants to address a dangerous condition. Okay, make sure that
Why don't the tenants have an equal obligation as to that? Why does the landlord have that obligation that the tenants don't?
The tenants need to make sure that, you know, that the tenants should make sure that there's fire extinguishers in the hallways.
No, we're not talking
They're not
about
moving
that,
to
right?
dismiss those portions of the case.
We're talking about the obligation to somehow control the tenant that caused the fire.
They could have alerted the fire marshal that there was a potentially dangerous situation. I mean, the
So
lower
could
court,
any of the other tenants, right?
certainly.
Where is the obligation coming from? Because I rent to you, I have to be your parole
Big
officer
brother.
or whatever, or your police officer?
Because they have a distinct. My client was not receiving complaints. They're receiving complaints.
100%. And again, we're not arguing here about whether or not the landlord had the obligation to make sure that the fire extinguishers were there and working, or that the sprinklers were there and working. The question is, that's not what we're talking about. We're talking about you are putting an obligation onto the landlord to somehow stop the arsonist. And I can't figure out what the scope of that obligation is.
Well, I'm saying since my client is not aware at all that there's a dangerous condition as another tenant, whereas the building in its unique position as in receiving complaints from all the tenants, they're in a better position to be aware of the dangerous condition.
But because
So
I know aware of something, I'm sorry, go ahead, Judge Kaplan.
No, I was going to say, even if they were aware, sort of the same question I asked your friend, Mr. Singer, under what law, under what statute, under what legal theory do they have an obligation to do something? And I get the concerns, but I'm just trying to find where there's a legal authority to request the landlord to do something more.
Sure. So I don't agree with the defendant that it's an authority, ability, and opportunity test. It's a foreseeability test, and this court ruled in De Los Santos, where a mattress was left in a hallway that that could have been it's an issue of fact, but that could have been a foreseeable risk of harm.
Right. Are you equating the fact that because in that case we said mattresses, these things were tending to be set on fire, and are you saying that because gasoline, I guess, reasonable could be used for that, it could also be used to start a car? I mean, how are you relating that to these facts?
That's exactly how I'm relating it. I mean, just combined with the complaints that the landlord was receiving about the tenant.
So you're saying that there was a reasonable opportunity to remedy the unacceptable conduct?
Yes.
In what way? That's what I'm at. You're saying that the landlord had the obligation to do what?
So if it's just a foreseeability test,
yes, but right, in order to have tort liability in this way, there has to be some obligation. Again, I'm saying to you, I assume that the landlord knows. What are you saying the landlord's obligation was?
aside from alerting the authorities, I mean, I could think of other things they could have done. They could have actually investigated it, questioned. Sir,
So
why do
wait
you
a
have
second. You're saying that the landlord would have to go to the tenant and question the tenant?
I mean, I think landlords question tenants for multiple reasons, for things that they might a dangerous possession they might have in their apartment.
Okay, thanks very much. All right, so now we're back, we're on the replies. So we have 2 and 3. So let's start with the appellant.
I think the court's rightly identified in the questioning the issues in this case. And the first one, in respect of duty, which the First Department has adopted by affirming the trial court's decisions in other cases, like the Musano case, is a landlord does not have a duty, and to expand the landlord's duty to patrol and police the behavior of its tenants would be a
Counsel, let
bridge too
me
far.
just, let me interject for a second. I want to make sure we're all on the same page. You are not arguing against summary judgment with respect to whether or not you had adequate fire extinguishers and your building was adequately safe according to whatever the building standards and common law is. Or we
Yes,
agree
Judge.
that that's not what this appeal is about.
There are expert reports on both sides. That would be the definition of a question of fact.
Okay,
So I'm
so
not
we are
arguing that
talking
point.
now. The only thing we're talking about now is the respondent's view that the landlord had, and again, I don't know what, but some obligation to get rid of this tenant or to stop this tenant from starting the fire.
Yes,
Or
Judge.
to
because that dramatically
investigate.
to investigate. Yes, Judge, because that dramatically changed the nature of the issues before the trial court and the jury in this case. And I think the jury being asked to opine on whether the landlord's duty existed in this context is contrary to law. And that's why we've moved to dismiss this particular aspect of the case, because it's a bridge too far and it placed on the landlord a responsibility that has never before been adopted in New York First Department jurisprudence. So I think that's where the trial court erred. And the trial court, the way they went about it, they basically said we had an obligation to inspect the purpose of the gasoline in the apartment. And again, there's no basis in law for a landlord going to knock on the door and saying, hey, tell me what you're up to with this. That sounds like a good reason. That sounds like a bad reason. And the landlord's got to decide if it's a good or a bad reason. If the person seems credible or not credible, that's making the landlord de facto police report. And that's the last thing we need is landlords running around New York City pretending they're the police department. They're not trained for it. They're not experienced for it. It's not what they should be doing. They should be renting, and people pay their rent. They get to stay. That's the way rent
Okay,
works.
got it. Okay, thanks. And now let's do the other reply. You have 2 minutes, counsel.
Who's
There's no other, I mean,
who's replied? There's no one else.
I thought, well, no,
Further
I gave
cross-appeal.
5 and 2, 5 and 2, and 5.
Yeah.
So, all right, if no one wants it, it's good.
I
We're
think
good.
that's the next case.
Oh, yeah, you're right. I'm sorry. Okay. Thank you, counsel.
Yes, Judge. Thank you. Thank you, judges.
I'm sorry, go ahead. Okay, thank you. Number 6 and 7.
We're doing
Oh,
that
we're
last.
taking out of, yeah, yes, I understand. We're
sorry.
taking them, we'll take them at the end. Number 8, People versus Jaquan Moore.
Good afternoon, Your Honors. Elizabeth Lagerfeld for Mr. Jaquan Moore. It please the court. The gun that police discovered during a legal suspicionless frisk of Mr. Moore must be suppressed. Here's what the suppression court correctly found happened. There was an anonymous call about a dispute with a gun. The police pulled up to the sidewalk. They saw 2 men who matched the physical description, but there was no fight and there was no sign of a gun. The 2 men were
However,
talking.
counsel, this is Justice Pittsburgh. There's a video here from the body cam. Is that correct?
Yes, Your Honor. Yes, Your Honor.
And the police officers, as you indicated, had they received an anonymous tip that there was a person on a corner wearing red with a gun, right?
That's correct.
And when they rolled up on the corner, there was a person wearing red, correct?
That's right. It was 2
And
men.
at that point,
Yes.
do they have enough information to at least go and inquire?
Yes, Your Honor, and that's
And
what
then
this-
when they
this-
get out of the car to go and inquire, this is where we might differ on what we see on the video. But is there some reasonable view that the person in red put their hand near their pocket?
I would say the most important thing about that moment on the body cam is that Mr. Moore, whatever you think he is or isn't doing with his hands, going from holding a takeout bag like this, putting his hands down, the officer says, "Don't put your hands in your pockets." And he immediately goes like this and he holds his hands still. And by the time the police officers reach him and grab his arms and start frisking him, this is what he's doing. He's holding his arms out like this. And the police officer testified
Just
that he
wondering
obeyed the
how
order.
I'm just wondering if we're glossing over the interaction, the hands up and down, and the knowledge of a person with a gun. Are we glossing that over that? Like, have we entered into reasonable suspicion at that point?
No, Your Honor. The first thing I would say is that that wasn't really the basis of the court's ruling. So that's why it was litigated this way. But since this is something that seems to be important to you, I will just say that the key about this whole interaction is that nothing Mr. Moore is doing is out of the ordinary or suspicious. That's in contrast to all of. Go ahead.
Well, so let me
Yes, Your Honor.
ask you, counsel, if I look at the video and I think he's putting his hands in his pocket and there is a report of a man wearing red on the corner with a gun. And when I come up to the guy, he puts his hands in his pockets. You're saying that there's nothing suspicious about that?
I am. And if you
Okay.
look at, first of all, the police officer testified on cross. He didn't put his hands in his pockets.
He
The
was going
officer,
to put his hands in his pockets.
well, the officer
right?
was
His hands are
concerned that
going
he
up
might.
and down. So
And so the
let's
officers,
just assume
I'm
that
sorry,
the
go ahead,
video
Your Honor.
shows what it shows. 1 second. Let's assume that the video shows
Sure, go
what it
ahead.
shows. And then when he puts his arm up, there's clearly the pocket is open wide. I mean, the pocket's pretty open. It's pretty easy to see inside that pocket, right?
Well, Your Honor, what the court found, factual finding of the court, and the body cam shows, and the officer testified, is that he frisked him before he saw a gun. So there was all this testimony about there being big pockets, there being open pockets, but that's all irrelevant because he frisked him first. He frisked him before he saw a gun. And that's what the court held. And the reason there was some confusion on that is that he initially wasn't sure. And then when confronted with his grand jury testimony, he said, you know what, you're right, I frisked him first and then I saw the gun. So the frisk has to be justified on its own without any visual of a gun.
All right, let me just step back for a second because you didn't address the fact that your client executed a waiver of appeal. So this, and we agree that this issue is waived if the waiver is good, right?
Right. If the waiver is good.
So I mean,
so
I'm looking at what is it about the waiver that you don't think is good?
So under the specific circumstances of this case, the waiver is not knowing and voluntary. So I ask your honors to put yourselves in Mr. Moore's shoes. He has a 10th grade education, and this was his first criminal conviction. So when
we ever held that circumstance invalidates a waiver of appeal?
No, Your Honor, it's a totality of the
Okay, and he has a
circumstances that I
lawyer,
haven't
right?
finished.
He has a lawyer who's
Of
got
course, Your Honor,
an
he does
advanced
have a lawyer.
degree. He's got a lawyer
Of course, Your
who has
Honor.
an advanced degree and who knows what the
Yes.
lawyer's doing. Okay, so go ahead.
Well, Your Honor, that's actually coming right to my point, because what the way that the court diverges from the model colloquy in this case is that they don't talk about there being an appellate lawyer. They don't have, like, whether they don't say he has a right to appellate lawyer, and they talk to him about, you will have the right to go to an appeals court. Now, for us, you and I know, when he says you,
Well,
that
the
means your
written
lawyer.
waiver says that, right? The written waiver says it.
That's true, Your Honor.
And,
But
and
this
the court
court has
made sure that
repeatedly,
he went over the written waiver with his lawyer, right?
the court confirmed that he had spoken to his lawyer. Yes.
Okay. All right.
But
Thank you. I'm sorry, I have to cut you off. You have some time on. Okay.
Okay, got it.
Good
Respondent?
afternoon. Sorry, good afternoon, Your Honors. May it please the court, Jonathan Gold for the Office of the District Attorney. As to the waiver, I believe Your Honors hit the nail on the head. This was clearly the defendant was, clearly asked, several times, do you understand, you've gone over this written waiver with your attorney. Defendant stated on the record, my attorney has explained it to me. If there was a defect in the oral colloquy, I think it's important to remember the jurisprudence, suggests that imprecision or overbreadth or shorthand in the oral colloquy will not render a waiver unenforceable. And In fact, Rosario, decided last year by this court, says that this identical written waiver has been upheld to show that the defendant is not waiving the right to appellate counsel, which is exactly what, in my opinion, a sensible reading of this
I have a
waiver.
question. So counsel, assuming, like, if we were to move beyond the waiver issue and talking about the suppression issue, the police officer gets this anonymous tip, person wearing red, standing on the corner with a gun. They get to that corner, they see a person wearing red. They approach this person, and it could be argued that the person's hands is in the air, and this police officer takes his hands physically, opens the pocket, and looks inside and sees the gun. Why isn't there something wrong with that?
I think at that point, given, because I believe, Your Honor, it's not simply that there's a man in red with a gun, it's a man in a very distinctive ensemble that was described in detail by in the 911 call, that he was standing there disputing with another man in gray who was also, the officers also, they responded very quickly. They saw both of these people, this was particularized information, and part of that information was that the man in red has a gun. So I think that, at that point when, regardless of what specifically is going on, when the defendant, makes a motion toward his waist, toward his pockets, I think it's perfectly reasonable for, at that point, for the officers to have reasonable suspicion to act as they did, and that's exactly what the trial court held in its decision on this.
Okay, thank you, counsel. Counsel, you have 2 minutes for reply.
Yes, Your Honor. I'll start with the appeal waiver. I just want to make the point that this court has repeatedly held a written waiver is not enough to cure issues with the oral colloquy, and that's especially true in this case, where, as I said, Mr. Moore only has a 10th grade education. And I think just need to go back to, in his particular case, because he never had taken an appeal before, it's different from a lot of other cases where it might be obvious, as it is to you and me, to some defendants, that when the court says you have the right to appeal, that means your lawyer is going to represent you. You, in that case, you're going before the court, your lawyer is going before the court. Mr. Moore did not have that background, and he had no reason to believe that he would have had a lawyer. And that's critical.
But he has a
because
lawyer
without
who's a counsel. He has a lawyer who's going through the written waiver with him. He says he understands it. We expect, he's got the lawyer. The written waiver says, even though it wasn't explicitly said that we will pay for a lawyer on appeal, the written waiver says it. He goes through the written waiver. Why shouldn't we assume that he understands what he says he understands?
Well, he said the court has an independent obligation to ensure that the defendant understands what they're waiving. So
And
the
court asked him that question, right? Do you understand this? Did your lawyer go through the written waiver with you?
He said that his lawyer explained the appeal waiver to him well. We don't know what that content was. And we can't defer everything to the defense attorney. So that it's really the court's obligation. We don't know what that conversation was offline. And again, in this particular case, I think it really matters because Mr. Moore had no prior experience with appeals. Thank you.
Thank you. Thank you, counsel. Cole versus Memorial Sloan Kettering.
Okay. Yeah, yes. Good afternoon.
Go ahead.
People versus De Leon.
Oh, I'm sorry. Yes, you're right.
Sorry.
Sorry. Well, you know what, Mr. Cole, let me skip you for a moment. I have one other case to do before you, okay? So hang on for 1 minute. People versus Raul De Leon. I'm sorry. Go ahead, counsel.
It's all right. Thank you, Judge. Good afternoon, Your Honors. May it please the court, Marielle Stein of the Legal Aid Society on behalf of Raul De Leon. This court should reduce Mr. De Leon's sentence from 10 years to 8 years in the interest of justice. As respondent concedes, there is significant mitigation in this case, including Mr. De Leon's extensive history of substance abuse and his profound remorse for his actions. This case is a tragedy. I'll start by saying that right off the top. I I don't think we can look at it without looking at the role that his history of substance abuse played in this offense. We know that long-term substance abuse can cause impulsive behavior, impaired decision-making. The record shows that he struggled with this really throughout his entire life, starting from childhood, going through to adulthood, through to this offense. We also know that PCP intoxication itself can cause violent behavior, and that effect is enhanced when it's combined with other drugs and alcohol. Here we have history of addiction. We have Mr. DeLeon, who was in active addiction at the time, and he smoked PCP that was contained within marijuana, which is kind of like a perfect storm for him to be particularly vulnerable to the effect of the PCP on his brain and ultimately on his behavior. And I'd also note that this history of addiction also explains why he was in a position to receive an enhanced sentencing range in the first place. All of his prior offenses are drug-related or property crimes arising out of.
Counsel, I have a question. How do you deal with the extraordinarily brutality of the crime on his own mother? Should that be a consideration?
Like I said, Your Honor, to start, this is a tragedy. And this court, first of all, has reduced sentences in violent cases before cases involving brutality, violent attacks. So that should not prevent this court from reducing here. But I
So
want to
the
draw this.
sentence, I have a question. The sentence that he received, that was already a reduction from what he was exposed to, right? A significant reduction, right?
It was less than his exposure, but as much as he would have received had he gone to trial on the indictment. He pled guilty to not the top count of the indictment, but an equivalent charge.
This was a plea on an SCI, right? So that
Correct.
he could dismiss the indictment.
It dismissed the indictment, but the top charge of the indictment was a B violent felony, excuse me, equivalent to what he actually pled to, which was also a B violent felony. So the
counsel,
sentence is less than his exposure.
Counsel, I have a question. Isn't it true that the minimum was about 8 years for the Class B felony and the maximum was 25? As my colleague said, it was on the lower end of the spectrum.
That's correct. It is on the lower end, but this court can still give the modest reduction that we're asking for.
So you want the minimum? You want the bare minimum?
I wouldn't call 8 years in prison the bare minimum. That's an extensive
So a Class
period
B
of time.
felony has. Can I ask you a question? What is the minimum for a Class B felony?
For Class B violent felony, for a second violent felony offender, it is 8 years.
Okay, so that's the minimum, correct?
That is the minimum. The legislature.
That's what I thought, counsel. I thought you were saying it was not the minimum.
Oh, no. I apologize, Your Honor. It
I
is
misunderstood
the
you then. I thought you said it wasn't the minimum.
No, it is. There are circumstances where the legislature has found that 8 years is an appropriate length of incarceration for a B violent felony offense. This is one of them. I'd also note that, his remorse, his grief and guilt for what happened in this case is profound, and it is evident throughout the record.
It's profound, counsel, because it's his mother, right?
Yes.
Okay, and the mitigation that we're talking about really is just him having been addicted to drugs.
It's that he has dealt with this addiction through his entire life, that it played a role in his commission of the offense, which this court has found relevant in reducing sentences in the past. This is, a totality of the circumstances, what happened here, what went into the sentence. All of these are factors this court can consider.
I mean,
And
the mother was so brutally injured that she had to have one of her eyes removed, ultimately.
yes, it's
I mean,
horrific.
this is a terrible situation. I mean, so the 10 years was close to, it wasn't the minimum, but it was close to the lower range of the sentencing, lower end of the sentencing range.
It was. That doesn't mean that this court can't reduce it further.
So, counsel, I have a question. Also, the victim there wasn't a victim statement because the mother was uncommunicative as a result of the injuries and is now in a nursing home. Isn't that correct?
That is correct.
Okay, thank you, counsel. Respondent, people?
Good afternoon, Your Honor. It's Joseph Tuck for the respondent. The sentence imposed here, fairly captured the gravity of the crime and already reflects leniency. Defendant's actions were extraordinarily brutal, as Justice pointed out. Mrs. Guadalupe's face was covered with blood when she was found. Her eye was dislodged from its socket. She was in a coma. She had extensive bleeding to her brain. There's been irreversible harm to Miss Guadalupe. She had multiple surgeries, the removal of her eye, and permanent alteration to her cognitive and speech functions. She's in a nursing home at the time of plea and sentencing. They couldn't speak to her.
Counsel, how do we weigh into this? I have a question. How do we weigh into the fact that the defendant was on drugs at the time of this incident?
Justice Michael, that's already been weighed in, and that's the point. The leniency of this crime, defendant did not want to plead to a crime that involved intent. So it was agreed that he pleaded the SCI, and he would plead to reckless crime. Reckless. He wouldn't plead to intent, and we gave him, the people offered him a sentence that was very close to the minimum. He was looking at 8 to 25 years.
Well, I mean, the fact that he didn't want to plead to intent, I mean, that is his right to decide like what he wants to plead to, especially if he's, saying that he didn't intend to do this, right? Because he was on drugs at the time.
Yeah.
That shouldn't be held against him, right?
No, it's not. I meant that as part of the negotiation. There was extensive negotiations here involving everything, and the court considered all the factors that are now considered that counsel's arguing as mitigating. His background, his childhood trauma, history of substance abuse, his expressions of remorse, his age at the time, and the time that he would get out of jail. All of that was considered in part of that extensive negotiations. The sentencing court was aware of it. The sentencing court considered it. And I think the sentence here is fair in light of the brutality of the crime and the other circumstances involved. So I don't see a need for this court, in the interest of justice, for this court to lower his sentence any further.
Thank you, counsel. Counsel, you have 2 minutes on reply.
Thank you, Judge. Just briefly, on the subject of the negotiations, I do think it's notable, and this court should consider that while these negotiations were going on, the sentence itself was never in question. He took the first offer that was made to him. The only question was which violent felony he was going to plead guilty to. And while I understand that he was facing up to 25, like I said before, had he gone to trial, 8 years would have been an option for him to be sentenced to as well for the violent felony, which I believe was attempted second-degree murder. Functionally, he took the prosecution's recommendation. This is not a negotiated plea in the same way as many of the pleas that come before this court are, where the sentence has been bargained over, because that never happened here. And further, I would just note that my understanding is that all the negotiations were between the district attorney and defense counsel and Mr. DeLeon. So while all of this information is in the record, as it must be for it to get here, the court itself did not play a role in these negotiations. Let
me just say, counsel, you keep saying if he had gone to trial. If he had gone to trial, the court could have sentenced him to 20 years, correct? Particularly because of the brutality of the crime.
He could have been. I only say that
that would not have been out of the realm of possibilities, right?
I just say that to contextualize the question of his exposure.
Okay. All right. Thank you very much, counsel. Thank you, counsel.
Thank you, Your Honor.
All right. Now, Cole versus Memorial Sloan Kettering. Mr. Cole, you have 5 minutes. Go ahead.
Okay, I clarify in brief only 5 issues, as you gave me just 5 minutes.
Well, I gave everybody 5 minutes, right?
Okay,
so go
that's
ahead.
Fine. Okay. Regarding my motion to dismiss Dr. Cook's testimony, is the expert. I just want from attorney Zamiatin a one-word answer. If he perjured his credentials, yes or no? Issue number two, regarding the motion for summary judgment Was it fair to file in the county clerk's office all my important filings and lower courts decisions? The only place I could see them after many months on the last day, the delayed decision of dismissing my case was filed. Regarding the pictures that I submitted to the lower court, and the lower court made fun of it. Crucial evidence I filed were ignored or disregarded in the lower court. All the pictures I filed in the lower court were in color and clear, while when filed in the county clerk's office, each one of them appears as a big black stain. And like this, they were put on the record. These pictures are evidence and worth more than 1,000 words. In China, it's more than 10,000 words. All these pictures were given to appellant from the files of the physicians who took them. The black stains, which is actually like redacting, are hidden evidence. Now, this one, maybe I missed it. I'll repeat. Regarding my motion to dismiss Dr. Cook's testimony, I just want from attorney Zamiati a one-word answer. If he perjured his credentials, yes or no?
Yeah, you just said that.
Okay. Now, the last issue is, I would say, the most ultra incriminating finding, which I filed in the lower court. It's regarding the Dr. Duncan's, it's an independent radiologist, CT scan analysis. I filed it in the lower court with the original CD of MSK's CT scan. It was vigorously, deceptively, and illegally, and I'll explain why illegally, fought in the two courts, the lower court and this court. Attorney Zamiatin got the opposition to the motion for summary judgment with Exhibit W, which is Dr. Duncan's CT scan analysis. On 7/6/2018 at 8:07 a.m. I made a mistake in the amendment, and you will see I wrote there 7/7, but it's 7/6/18. The post receipt as evidence when I is with me. Their physicians, Dr. Neal, Dr. Singh, and Dr. Cook probably were in shock, realizing that MSK's forged CT scan analysis was discovered. You don't understand what's the meaning when the radiology department make a forgery. It relates to all surgeries performed in this hospital.
Okay, Mr.
The 5 minutes
Cole,
elapsed.
your time is up. Your time is up. We
I do
have
have
your
time?
papers.
No, your time's
Your
up.
time to argue.
Okay, anyhow, the
is up.
amendment, the amendment is a sure reply. Please look at the amendment to the opposition, to my opposition. It's a sure reply.
Okay,
By the other
got
party.
it.
It's a sure reply, so it should be rejected.
Okay, all right, great. Thank you. All right, respondent?
Yes, good afternoon. May it please the court. My name is Irina Semyatin for the respondents. So to summarize, this is a medical malpractice action that was filed by Mr. Cole. And
I have a question, counsel.
Go on.
In terms of your expert and his credentials, what were his credentials?
He's a head and neck surgeon, and he's double board certified in head and neck surgery and dermatology. And any sort of allegations relative to his credentials aren't actually before the court because that was not, it wasn't noticed for appeal. So that was a separate motion that was decided by Justice Kelly, and that was not appealed. The summary judgment motion was separate, and that was before the court now. And so in the lower court, Justice Kelly found that the plaintiff had not shown that there was any sort of deviation from the standard of care or proximate cause, which is required
Am I correct, Counselor, that the plaintiff did not submit an expert affidavit in opposition to the summary judgment motion?
Yes, Your Honor, that's exactly correct. Yes, and so for that reason, the Justice Kelly granted our summary judgment motion because, I mean, it's medical malpractice action, and you need an expert to show any sort of deviations from the standard of care.
Sure.
Plaintiff stated that he didn't need an expert because it was, readily apparent. Unfortunately, medical malpractice does not work like that. You do need an expert. We presented one. Plaintiff did not oppose with one. Therefore, you just can't meet and properly respond to a motion for summary judgment without an expert. And we have enough evidence to show that the surgery was properly performed, that it was necessary, that it was adequate. There's just nothing in the record to show to the contrary, especially without an expert who could point out any sort of deviations from the standard of care.
Okay, thank you, counsel.
Thank you so much.
Mr. Cole, you have 1 minute to respond if you want. You have 1 minute.
Yes, I repeat.
Maybe you'll respond to why you don't have an expert. Maybe you'll respond to counsel's argument that you had to put in an expert's affidavit.
The resection surgery at the right ESC didn't have any scientific backing for the necessity to perform it, except for Dr. Neal's motivated, irrational, and criminal desire. MSK Specialist Committee investigating my treatment found that Dr. Singh successfully removed cancer from the EAC. However, the defendant's expert, Dr. Cook, finally admitted that no cancer was removed. And nevertheless, the surgery was an absolute must, quotation marks. And Justice Kelly approved this paradox. One more point. I repeat,
Mr. Cole, I have to have you wrap up, okay? We have all the papers submitted. I need you to finish. We have all the papers that you submitted. We've have all the cases and everything you cited. So we'll take a good look at it, okay? Thank you. Thank you, counsel.
Okay. Thank you. Please, okay?
No, Mr.
Duncan,
Cole, I've got to move on to the next case, please.
She's got to move on.
Okay, thanks a lot. And have a
Thank
great
you.
day.
You too. Thank you, counsel. All right. Number 12, West Point Home versus Dormify. Go ahead, counsel.
My computer.
I think you're on mute.
Can you hear me now, Your Honors?
Yes.
Yes.
All right, I'm sorry about the delay. What this case comes down to, very simply, even though the facts are somewhat convoluted, is whether or not the plaintiff is entitled to proceed with the lawsuit based upon a very extensive complaint that was filed. The sole basis for the motion to dismiss was that a foreclosure and sale agreement absolutely forecloses the claim that of a fraudulent transfer. we respectfully suggest and brief this issue thoroughly, that the allegations that the transaction was a disguised sham to cover up what was really a transaction for an entire business should not be protected by the safe harbor provisions of the fraudulent transfer statute or Article 9 of the
Well, doesn't the
Commercial Code.
statute specific, counsel, doesn't the statute specifically say that you can have a void, under the Voidable Transaction Act, that enforcement of a security interest is not voidable?
No, it doesn't say that. It says that it's subject
Well,
to a
I'm
good
reading
faith.
E, a transfer is not voidable under paragraph 2 if the transfer results from A, enforcement of a security interest in compliance with Article 9 of the UCC. Isn't that what happened here?
No, it was not an enforcement of a security interest. There was no security interest, Your Honor, and the one valuable
Was there
asset.
not a Article 9 sale of collateral?
That's what they said, but what I respectfully suggest, it was not an Article 9 sale. In order for it to be an Article 9 sale, it has to be a sale of an asset that is owned by the secured creditor. The asset that was sold here was not owned by the secured creditor. The college contracts was the only valuable asset of the company, and the foreclosure and sale agreement specifically says it's not subject to foreclosure or sale in the absence of an assignment by the colleges. Yet the transaction went ahead, and not only was in effect the college contracts transferred, I want to point out that it was nowhere mentioned in the court's opinion or in the briefing what happened here after closing. What happened after closing is
First, isn't it true that anything that didn't require third-party assent was transferred? So those contracts, some had third-party consent and some didn't. And the sale says anything where there's no third-party consent, it's transferred, correct?
where there's no third-party consent, it's not transferred, but it was
It
transferred.
is transferred.
No, it says if there's no consent, it's not transferred. It says all that's transferred is what is by closing has been consented to by the colleges. If it's not
So
assented to by the
any contract where assent wasn't required was transferred. It's only where you needed third-party consent
yeah,
that
but
that
every
wasn't
college, every
transferred.
contract required consent. That's the point. The point is this is a typical contract between a small company, OCM, OCM, I mean, with colleges, in which it's typical where a college would say, you have to make a contract. The contract, as best as we could understand it, although we don't have the contracts, is that it required a contribution by the OCM, a capital contribution to the university. Then they would get the addresses of the students who had committed to go to that school so that OCM could market directly to the parents. That was the one valuable asset. It's the asset that Dormify, its competitor, did not have, which put Dormify at a disadvantage. So what happened here
All
is
right,
that
so let me ask you a second question. How much was the sale for?
the sale was for almost $6 million, which was a
And how
discount
much
value.
was how much were the security interests?
Supposedly 60 million, but that's questionable whether it was actually 60
I
million.
know, do you have any indication that it wasn't, anyone could find out. Do you have any indication that it wasn't 60 million?
There's evidence that there was no default on the payments, but that
I'm asking you whether or not you have any evidence that the secured debt, which would be readily easy to see under the UCC, was less than 60 million?
no, not hard evidence.
If the $6 million should have been 1 million or 0 million or 20 million, you still would have no damages. You're an unsecured creditor with a general claim.
That's not correct, Your Honor. If the traditional way of dealing with an issue like this is not the Article 9 safe harbor, but a 363 sale and bankruptcy. As a matter of fact, it's ironic that Dormify, subsequent to this transaction, filed bankruptcy.
I have to disagree with you. I know plenty of people who would do an Article 9 sale. The fact that you didn't want the Article 9 sale is not.
Your Honor, respectfully, Your Honor, plenty of people do an Article 9 sale because it's safe harbor, so you aren't accused recklessly of a fraud. But here you don't have that. You have an entire situation of facts where the initial inquiry was to buy the whole company, and then someone on the other side, namely Alan Quasha, came up with an idea that we can get around buying the whole company by secretly just buying the hard assets. But we only bought the hard assets if on one condition, and this is the key. The seller, OCM, had to agree. The bank could not sell the college contracts. OCM could sell it, and they sold them for nothing. That's the fraudulent
Okay.
transfer.
Got it. Okay, thank you. All right, respondents?
Good afternoon, Your Honors. May it please the court. My name is Ramsha Ansari, and I, from Warsh and Garing, represent respondents Quadrant Management, Inc. and Alan Quasha in this matter. Respondents respectfully request this court to affirm the lower court's decision granting respondents' motion to dismiss appellant's claim for fraudulent transfer for two reasons. First, the amended complaint fails to state a claim for fraudulent transfer as it's written. Second, the documentary
Well,
evidence.
what do you say to counsel's argument that no contracts were transferred for $3 million?
Judge, there's simply just, counsel does not provide any evidence for that at all. The websites and commercial contracts claims could not be sold because they're not collateral under Article 9, but there's no authority for this by the appellant. And instead, commentary to Article 9 of the UCC states that general intangibles can be collateral subject to security interest, and that's exactly what has happened here. Appellants failed to state a cause of action for fraudulent transfer under New Jersey law. First, the appellant must prove whether the debtor has put some asset beyond the reach of creditors, which would have been available to them, but for the conveyance, an appellant concedes that they would not have been able to establish this first prong. Here, OCM owed the appellant, an unsecured creditor, $3 million. An appellant concedes that OCM owed its secured creditors $60 million on page.
He backed off of that, counsel did, I'm saying. He said, but I mean, obviously, if there are UCC filings, you can see how much the secured creditors have. So I don't know. I mean, I think that's a late back off from the number, right?
Sure, Judge. But you know, turning to my second point, the FSA is dispositive here and establishes respondents' defense to any valid fraudulent transfer claim. Here, the plain terms of the FSA establishes that the foreclosure was an enforcement of a security interest in compliance with Article 9 of the UCC, and it states that on page 106 of the record. I quote, as a result of the numerous continuing defaults, the lenders are entitled to under Section 9 of the UCC and the loan documents to sell and transfer all of the credit party's personal property subject to the agent's security interest. And the appellant just it's factually and legally untenable for the appellant to suggest that the FSA is not documentary evidence as they do in their brief. And Your Honors, this appeal asks nothing more than for the court to apply its own settled law and bedrock principles that bare-bone legal conclusions with no factual specificity cannot survive a motion to dismiss. And the dismissal is required where documentary evidence, as here, conclusively establishes a defense as a matter of law.
Okay, thank you, counsel. Other respondent?
Good afternoon, Your Honors, and may it please the court, Kelsey Cleary on behalf of respondents Clarity Global Capital Management and Lisa Myers. There are three independent reasons the dismissal should be affirmed here. First, the UVTA does not permit liability against the Clarity respondents because they were strangers to the transaction. Second, the complaint fails to allege the elements of a fraudulent transfer, and in any event, the transaction is protected by the UVTA safe harbor. And third, the complaint fails to meet the heightened pleading standard required for fraud-based claims. First, the complaint fails because the Clarity respondents are not proper defendants under the statute. The complaint does not allege that they were parties to the transaction or that they ever owned or received the assets. And the UVTA only allows recovery for money damages, which is all that's sought here, from a limited class of transferees or beneficiaries. And there's no allegation that Clarity or Ms. Myers fit any of those categories. Clarity was at most a minority investor, downward from any alleged fraudulent transfer, and Ms. Myers was even further removed, and there are no allegations to support piercing the corporate veil or agency liability. Second, as you just heard from Attorney Ansari, the complaint does not state the elements of a fraudulent transfer, and the safe harbor would apply here because this was an Article 9 foreclosure.
Right, but I don't want you to repeat the arguments that were already made, okay?
Absolutely, Your Honor. I will just touch on bad faith. Appellate now argues for the first time on appeal that alleged bad faith somehow renders the safe harbor inapplicable, but there are no allegations that come even close to alleging bad faith by the Clerisy respondents. The only case cited in the brief, in appellant's brief, involved detailed allegations of collusion, lack of marketing, and insider self-dealing, and none of that is alleged here. Instead, the complaint explicitly alleges that an independent investment banker was hired, the banker considered multiple different offers, and there are no allegations suggesting lender misconduct. And notably, there are no claims against the secured lenders. A secured lender has no economic incentive to sell collateral for less than it's worth. Doing so would only diminish its own recovery, and there's no allegation that anyone compelled the lenders to act otherwise. And last, the complaint is deficient because it does not plead fraud with the particularity required by CPLR 3016B. The allegations are conclusory and do not identify any specific misrepresentation, reliance, or fraudulent act attributable to Clerisy or Ms. Myers. Appellant asserts that the heightened pleading standard does not apply to fraudulent transfer claims, but cites no authority for that position. And New York courts routinely apply it, whereas here the claim sounds in fraud. Thank you, Your Honor.
Thank you. All
Your
right,
Honor,
counsel, you have 2 minutes.
Well, I might say, Your Honor, I don't make a big deal about this, but nobody told me I used up my 5 minutes. I answered one question of the court, and then I was cut off. But I'll make my 2 points in 1 minute each, if I may.
Wait. Let me go back and say, you did use up your 5 minutes, and I thought I had made that clear. If I didn't, I apologize. You used up your first 5 minutes.
You just said thank you. Thank you, counsel.
Yes, I
So,
mean, I guess, okay, I don't want to, if
No,
it
I'm
was
not making a
unclear,
big
I
deal about it.
apologize.
I can make
So
my
let's go
points.
back to where let's have argument
All
about
right,
your case.
let me
And
make my
ask
two-
you this.
Yes,
Sure,
ma'am.
and then I have a question for you. Go ahead.
Oh, you want me to go ahead? Okay. Let me make this following point that's lost in the shuffle here. If you read the fraudulent transfer statute, it makes it very clear that the burden is on the defendant, not the plaintiff. These are listed under defenses. What they're saying is the pleading is inaccurate because it doesn't avoid the Section 9, Article 9 safe harbor. That's an affirmative defense. And all I'm suggesting to the court is the following. And you can read the FSA, the foreclosure and sale agreement, for yourself. The sale in there is a sale of college contracts by OCM, not by the bank. The bank did not foreclose on the college contracts. Now you have to look at this. My argument is very simple. You have to look at this as a fraudulent transfer of the college contracts. And what's important here is the following. The FSA says we're not transferring the contracts unless there are consents before closing. And afterwards, what does it say? It says, seller, OCM, you have to cooperate to make it happen. That's not an Article 9 transaction. So this entire argument by the defendants that the foreclosure and sale agreement is on its face an Article 9 transaction is just incorrect. If it was an Article 9 transaction, there is no reason for the seller, OCM, to be agreeing to anything. It's a secured loan, there's a foreclosure, and a separate sale to the buyer. That did not happen here. The seller was OCM and the fraudulent transfers of the college contracts. And secondly, I remind the court, which I'm sure you don't need reminding, this is at the pleading stage. No discovery was permitted, and the complaint is not a bare bones complaint. It has 100 paragraphs. It alleges facts in detail and the cooperation of witnesses. If it needed amendment, we could amend it. And I think fairness in New York jurisprudence dictates that we be allowed to go forward. Thank you.
All right, I want to just ask you one question. Did you not plead in the complaint that there was 60 million of secured debt?
I believe that I can see that there's 60 million of debt on its
And
face,
you are
but
an
that doesn't,
unsecured, and 1 second, and you're an unsecured creditor behind that 60 million.
they're
in
not a
secured debt,
secured
correct?
creditor on the but they're not a secured creditor, Your Honor.
No, I'm just asking where you are. You're behind the 60 million of secured debt.
No, we're not. I'm trying to explain. The college contracts in a bankruptcy are not secured.
Okay. All right. Thanks very much, counsel.
Thank you.
Have a good day. Thanks, counsel. People versus Erica Yu.
Good afternoon again, Your Honors. Marielle
You have
Stein of the
1
Legal
minute.
Aid.
Make it count.
Do my best, auctioneer. Marielle Stein of the Legal Aid Society on behalf of Erica Yu. This court should vacate the improperly imposed surcharge. I just want to draw the court's attention to one thing. In their no position letter, respondent notes that they're choosing not to argue the retroactivity of the statutory amendments. However, that's not really relevant in this case. Erica was sentenced on November 2nd, 2020, months after the change in the law became
Yeah,
operative in August.
No one's fighting about this, right?
I know, I just
No.
want to clarify,
Okay.
clarify for the court.
Yes.
And as well, the argument is preserved. For all these reasons, this court should vacate the surcharge.
Okay. Thank you.
Thank you, everyone.
Abrams versus Abrams.
Good afternoon, Your Honors. May it please the court. This appeal is addressing three direct errors. First, the injunction has to be vacated because there's no lawful basis to restrain Seppi Realty's property once the arbitration concluded. The arbitration award was entered only against Russell Abrams. All claims against Sandra Piedrabuena Abrams were dismissed, and Seppi Realty LLC was never a party to the arbitration and was never a judgment debtor. Sandra owned 99% of Seppi since its creation. Russell owned 1%, and that 1% membership was turned over. After that turnover, there was no debtor property left to restrain. Even before the turnover, New York law is clear. The creditor of a shareholder could reach the shareholder's shares, not the corporation's assets. Corporate real estate is not the personal property of the shareholder. There was no veil piercing, no alter ego finding, and no fraudulent conveyance finding. Yet somehow the trial court restrained Seppi's townhouse from sale and effectively required payment of Russell's judgment before Seppi could operate freely. That exceeds the Article 52 and fundamental corporate law principles. Second, once the arbitration dismissed all the claims against Sandra, the injunction became wrongful as to her. CPLR 6312 exists to compensate parties who are restrained under injunction when the underlying claims fail. And that's exactly what happened.
Let me ask you a question, counsel. Wasn't that property transferred at a time where there was a requirement that notice be given for that transfer?
No, it wasn't transferred. There was a contract. The notice provision.
Was any notice given?
The notice was only within 30 days of closing. There was no closing.
How did the property go away from one to the other?
It didn't go away from one to another. When are you talking about?
What happened to okay, fair. Okay, stop. You know the property was transferred from one owner to another, right?
No, this was owned since 2009 by Seppi Realty LLC.
And then what happened to it during the period of time that we're talking about?
Nothing. It's remained in her ownership, in that LLC ownership ever since.
Was there a 2022 transfer of the property from West 70th owners to Seppi Realty?
Seppi Realty had purchased the shares.
I'm going to ask again, was there a transfer in 2022 of the property from West 70th owners to Seppi Realty? It's a simple question.
I don't think it was the townhouse that was transferred. I think the apartments were purchased individually by Seppi Realty. There is a corporation that still exists, but it didn't have any assets from what I understand.
I mean, Okay. All right. Thank you.
And I mean, there are other points here.
Well, your 3 minutes is up. We have your papers. We have all the papers, and you don't want to argue against yourself, right?
There's nothing to argue about but against myself. That
Right. Exactly. Thank you. People versus Ashley Wade.
I forgot to unmute. Good afternoon, Your Honors. Legal Aid Society by Denise Fabiano on behalf of Appellant Ashley Wade. There's a lot going on in this case, so I'm going to rely on my brief for much of it, but I'd like to start with the request for a new attorney and the IAC claim in tandem, and then get to the legal sufficiency of the kidnapping/felony murder and finish with excessive sentence. Here,
Well,
Ms.
let's
Wade
talk
made-
about counsel. This is Justice Michael. Let's start with where you started with regard to the request for new counsel.
Yes.
How was that, in your estimation and looking at the record, not dealt with by the trial court in terms of specifically asking your client about the motion that your client had put in, and then responding and laying out where the case was and making a denial based on all of what was in the record?
Because Ms. Wade, in her request for the new attorney, specifically alleged, among other things, that there had been a complete breakdown in communication, that she hadn't heard from her attorney and talked to her
Well,
about
the case
potential
had been
defenses.
pending for 2 years, and her complaint was that she hadn't heard from the attorney in a few months.
I believe that the attorney had been on the case maybe 9 months total. So
So
why
she had
now?
another attorney before that?
That I believe she was happy with, yeah. I believe it was about 9 months.
What do
But-
you mean that she was happy with?
Well, I know she was happy with that attorney because they had to do an exam. She was examined at one point, a 7:30 exam, to be honest, and she had indicated, it indicated in that report that she was happy with her attorney. So she has this attorney now, and she's saying there's a breakdown in communication and that she hadn't heard from her 3 months leading up to trial.
Leading up to
and-
the hearing?
Hearing and trial, they occurred in one following the other. So once she's made that allegation of a breakdown in communication and that she wanted to discuss defenses, there's 2 cases, the Court of Appeals cases, Fredericks and Sides, I believe. Once you've
The
alleged.
record indicates that she wanted to discuss defenses, or that she said that she thought the lawyer didn't believe her. I just want to
Well,
make.
she alleged a lot of things, like a number of things, and I'm just focusing on the things that really triggered the demand for an inquiry here. She, in her written motion, she wanted defense counsel to confer with her about potential defenses, with enough time to prep for trial. And then once she's in court, the court says, well, why are you asking for an attorney, like to ask her to sort of like expound on this a bit? And then she says, I haven't heard from my attorney in the last 3 months. And she doesn't list it, has deteriorated to the point where I don't think she can represent my interests at trial. That allegation right there requires an inquiry under Fredericks and Sides, a breakdown in communication. And it not just requires an inquiry, it requires
Where
an
was the lack of inquiry? What was the lack of inquiry here? Because she gave her an opportunity to expound on what it was that she claimed to be the issue.
And once she explained what that issue was, the court was required to go further. That's not an inquiry unless there's an actual.
Go further and say what?
Well, talk to either the defense attorney to address her
The
specific
defense
factual.
attorney is right there. She asked the defense attorney, are you joining in this application?
Right, and that is not an inquiry about the breakdown in the communication. That is an inquiry, are you joining in this motion? And in fact, all the defense attorney said was, well, I'm ready for trial. That was the gist of what she said. That is not.
No, that wasn't all
responsive.
she said, counsel. Counsel, that was not all that she said.
Well, she
And
didn't
I'm
address
looking at the written motion. What she said, the written motion that she submitted is basically a form that you check off some stuff. And she said she didn't visit me and inform me of pertinent motions and make a bail application, which are all standard things that are in that motion. So
And in
there's
paragraph-
nothing in the motion itself that would indicate any of what you're talking about now.
Paragraph 8 on that motion, because that motion is 13 paragraphs long and 6 pages long. In paragraph 8, she says, request that counsel confer with her client without undue delay, and counsel must conduct appropriate investigations, factual and legal,
Yes,
to
that's a
determine.
standard. It is literally
It's a pro forma.
akin to.
But this
It's
is a pro se
it's a pro
defendant.
forma document.
This is a pro se defendant.
Right.
So
And it's
we
a
can't
right, a pro
impose more
forma,
than.
so
And once she gets into court, she continues with, I haven't heard. She follows up. I haven't heard from her in 3 months. She doesn't listen to me, and again, under Frederickson Sites, once that allegation is made, the court is required to conduct an inquiry that allows the court, and I'm quoting, to determine the nature of the disagreement and whether there's a potential for resolution. The court explored nothing. Defense counsel said she wasn't but she was ready for trial. And she was ready to go forward. That does not answer the specific allegation of Ms. Wade that there was a complete breakdown in the relationship. And in fact, it's borne out. It's borne out because—
Counsel, I mean, I don't want your time to run out without you addressing
I
the
know.
kidnapping issue.
Yeah,
So why don't you
okay.
move on to that?
Okay, so I'll skip over the IAC. I just switched to the. So here, this just was not a kidnapping. Ms. Wade suffered from pseudocyesis and believed that she was pregnant. However irrational this seems, this is an actual diagnosed condition where she has the firm belief that she's pregnant. And after this crime occurs, she consistently maintains the baby's hers. And if she believes the baby's hers, then the kidnapping and the felony murder fail. Those counts fail.
So just so that I'm clear that I understand your arguments on the kidnapping relating to the elements, you're not arguing that the elements are not there just because the elements are not there. You're arguing that the elements of kidnapping are not made out because of how the defendant, what her mindset was?
It really goes to her intent, yes.
Okay.
I mean, that's the gist of it, that she didn't have the intent to kidnap anybody, that both factually and legally, because of the backdrop of
Did the jury get an
pseudocyesis.
opportunity to hear that?
Yes, and we are asking, I mean, I don't think the evidence was legally sufficient, but I also would ask you to consider this under the weight of the evidence as well.
So
Because
factually, your client, with precision, right, so that the baby was still alive, cut out the baby from another woman's body after
Yes.
she killed her, right? And then
Yes.
took that baby and said that baby was her own. Are you saying like that doesn't make out the legal elements of kidnapping, or it doesn't make out the factual elements?
If she believed the baby was her own, then it doesn't make out the elements of kidnapping.
Okay.
Well, let me
If
ask you
she-
this. Couldn't the jury have found that she didn't believe that the baby was her own by the mere fact that when she was killing the mother, she made made sure not to go anywhere near the baby, so that couldn't the jury from that those facts find that she knew that the baby wasn't hers?
That could be one inference, but another inference consistent with
No, but
pseudocyesis.
How is this
different? That's not enough.
How is this
Again,
different? Counsel, how is this different from a situation where someone is attempting to abduct a child and when confronted says, I'm that child's parent? I mean, we've had cases like that where we found that. How is this different? Are you saying mainly because of her mental
Yes.
health issue?
Yes, that's part of it, Your Honor. And again, those cases, there were clear intent to abduct, where like the person flees when they see I'm her father, and he flee. Like that's People versus Antonio. He flees when he sees the police. We have a medical condition here. We have pseudocyesis.
She gave this child to another person and said, "This is your child," right?
She said I had
the
the baby. I had the baby. Yeah, I had the baby.
He was the testimony and the evidence at trial leads to one to believe that this person who she gave the child was the father of the child that she thinks was hers, right?
But she said I had the baby. Yes, it's consistent with pseudocytosis.
It's consistent with the evidence that the person that she gave the baby to was the person who she said, she had been telling all along that she was having a child for.
And that is correct. But
Okay.
pseudocytosis by definition is not that she's faking a pregnancy for 9 months. She, under the DSM, believed she was pregnant. She had all of the physical symptoms of pregnancy and went through 9 months of
Counsel, I just
believing
don't
that
want
she was pregnant.
Counsel, this is Justice Michael. I just don't want to make sure that we're hearing all of your arguments. So are you making any arguments regarding the legal elements in terms of, you know, the fact that the baby wasn't taken anywhere, that the baby was...
Well, yes, that she didn't have the intent to restrain. It really goes to her intent on the elements. The intent to restrain, the intent to abduct.
Okay.
So there are legal
So,
elements for sure, yes.
you want us to, you're saying that the jury heard this evidence of her mental health condition and what you're saying. You're wanting us now to reevaluate that and say, well, the jury got it wrong.
Well, yes, partially, but I also think ineffective assistance played into this somewhat too, because some of the facts were not fleshed out here. Because quite frankly, defense counsel wasn't aware of some of the facts and didn't
No, but
use
you
them.
didn't make that, you didn't make an ineffective assistance argument here.
Yes, I did, Your Honor. Yes, I just haven't addressed it. I skipped over. You had asked me to skip over to the next.
You didn't make a
Right.
separate 440
Oh, no.
motion, I think, Mike.
Oh, no, I don't have a
That-
440 motion, but I certainly raised.
But
the
I know
effective
you
assistance of
argued
counsel
it
here.
within the
Right.
context of this.
Okay.
That's what you meant.
So defense counsel, because of the failure to communicate with her client, didn't know many favorable facts when she started the trial, like the fact that it was the victim who had reached out to Miss Wade on Facebook. So this is not a case where she lured somebody in. On the day of the murder, it's the complainant who shows up unannounced at her apartment. She texts asking to come over. Miss Wade's in bed, depressed, and she's not replying. And then the victim calls and says, I want to come up. Also, contrary to the theory that she was lured anywhere, is that
What
Miss
does
Wade
that
did
have
not.
to do with anything? Just so that
Well,
I
I guess I'm
understand,
going
what's the
back to,
legal,
like-
just so that I understand the legal import of this that you're placing before the court. What is it?
That legally and under the weight of the evidence that the kidnapping is not borne out here. She just did not plan this. Somebody who plans to kidnap somebody, it makes no sense that she is going to murder somebody who she didn't invite over, take the baby, hide her, in plain sight. She knows she's found with the
Who
victim
said that
in
she
the
didn't
apartment.
invite them? Who said she didn't invite the person over?
The facts show that she did not invite them over. If you look at the texts, there are texts and, well, Facebook exchanges too. The texts are, I have some bottles to give you. And then the text exchange literally says, I can either, I can drop them to you, I can meet you at the bus stop and give them to you, or you can drop them to me. And they're going back and
Was all
forth.
of this in front of the jury?
Well, the texts were introduced as an exhibit, but it certainly wasn't brought out by defense counsel in her representation during the trial. So the texts themselves were admitted. So not only does that, it
Counsel,
undercuts.
okay.
Oops.
Let me just interrupt because I've already given you like way more time. Anybody else have any more questions right now? You have some time on reply, but I've given you way more time, okay? All right. So let's hear from respondent.
Good afternoon, Vincent Revelisi for the Bronx County District Attorney. I suppose I should start with the kidnapping. And I think we should remember that the evidence should be viewed in the light most favorable to the people in this case. And it's not necessarily the case that she didn't believe she was pregnant and yet then, I'm sorry, that she believed she was pregnant and then thought the child was hers. Because here, she was not having hallucinations. The expert testimony was that she was not having hallucinations. She killed somebody and took her baby out. So whether she believed she herself was or wasn't pregnant at any point, she still killed someone else and took her baby out. So she knew that wasn't her baby, regardless of what she thought about herself at any point. And that certainly could.
So that at least the jury had enough evidence to find that as opposed to that she was hallucinating or something like that. But then the question still becomes, how is this taking the child in a way that fits within the statute?
Well, in accordance with previous decisions from this court, for example, lying about being the parent is one way of preventing the child from being returned to the actual parent. Another way was by taking the baby out of the abdomen, there was still an existing living parent that didn't consent to that, and she certainly wouldn't have assumed she had consent from the father. She then continued to lie as the baby was placed outside with her boyfriend, who she had deceived into believing he was the father. And the baby was treated as that man's child until the real father was identified later. So for quite a while, for a few hours, she was able to prevent the baby from being returned to his rightful father. And that would be the kidnapping. It didn't involve escorting the child to a different place herself, but it was telling lies and causing the baby to be moved by her boyfriend. So that was enough for the jury to find that there was a kidnapping. And clearly the rest of the evidence supported that she did this intentionally to get the baby for herself, at least viewing the light in the most
How
favorable
does,
to the
I have a
people.
question, how, because the defense counsel really makes a lot of argument based upon the mental health aspect that negates the intent. What are we to do with that?
Well, the jury was told that they had to believe that she intended to take the child from the parent. So the fact that the jury found that means that they didn't believe it. And her pseudosciasis was before the jury. They knew that she was diagnosed with that. And taking the baby from a different person doesn't have to change what she believed about herself. So there's no reason why the jury couldn't find and why there was insufficient evidence to find that there was a kidnapping here, regardless of whether she believed at any point that she was pregnant herself. And the mental health issues, they were not being hidden from the jury, but the experts didn't find that she was hallucinating or that she had any reason why she couldn't understand what she was doing or why she didn't believe that what she was doing was wrong. So there was no mental defense, and there probably wouldn't have been a way
Counsel,
to.
can you address the failure to have a hearing on the request for new counsel argument?
Yes, I think the argument kind of is twofold. First, what she said originally in her original motion didn't really trigger the need for an inquiry because it was too broad, pro forma in general. But the judge did do a minimal inquiry, which is all that's required. And that inquiry didn't elicit anything new. The defendant really just repeated even a little less than what she had said in her written motion. For example, she said her attorney didn't visit her in the written motion. But then when asked orally, she said that she hadn't pretty much seen her since the last court date, which is less than never visiting over 9 months. That's just one court date. And the attorney explained she had been on trial for a while during that adjournment. So it made sense that she wasn't in close touch during that adjournment, but it didn't show that she had never communicated. And there was indications that after this motion was denied, they continued to communicate. So the judge was right in her prediction that this would work out because the defendant consented to her attorney being absent for one day of testimony and handling it without her when she didn't feel emotionally prepared to be there. And she trusted her to communicate for the rest of the trial. So the judge was right.
Did she ever raise that issue again after that? There was that one sort of form motion, then that discussion. Did she ever go back to it after that?
I don't
The
believe so.
defendant.
I don't believe so. I can't think of a time that happened, so I don't want to speak incorrectly, but I don't believe she raised it again after that. Certainly there was no motion after that. I don't know if there was a one line somewhere that might have alluded to it, but I don't think so. So what the judge did then was just basically making sure that what was in the motion wasn't a general statement of something more specific. And then when the defendant had the opportunity to speak anything that she wanted, she didn't say anything more specific than those general statements within that motion. And in fact, it was less specific. So there was really no reason to replace. But that minimal inquiry was enough. Had there been anything raised by the motion, that minimal inquiry was enough to show that it wasn't a breakdown in communications, including the fact that afterwards they continued to communicate. And then as far as the sentencing, we'd asked the court to affirm the sentence. It's substantial, but it's a sentence that it fits this particular egregious crime. As far as the consecutive versus the concurrent, it's not possible to have the felony murder consecutive to the felony of kidnapping. So that was a misspeaking on the part of the sentencing judge. But of course, it is possible to have consecutive sentencing for intentional murder and the felony of kidnapping, which are separate crimes that don't share elements. And all that has to be here is that there has to be a correction that the felony murder is not consecutive to the felony of kidnapping. But the intentional murder could be and should be consecutive as the judge intended, as it could have been had there been no felony murder conviction at all. And so we'd ask the court to affirm in all respects.
Okay, thank you, counsel. Counsel, you have 2 minutes on reply.
Okay, just quickly and briefly, I'm going to try to just touch on each thing. At every stage of this case, a defense counsel fell down, and Ms. Wade knew this. She requested a new attorney. She laid out why. She explained that she wanted to talk about defenses and that the relationship had broken down. That specific allegation went unaddressed and unanswered by the court and by defense counsel. And under Fredericks and Sides, that's impermissible under the Court of Appeals law. And because defense counsel hadn't been consulting with her client, she began trial unprepared, factually and legally. She didn't realize that who had contacted who first on Facebook, when she had registered for baby items. And she legally misunderstood her defense of EED. She didn't know she had to give notice. She didn't know that it would trigger the right for the people to examine her client. And that's indicative of the failure of communication. One leads to the next. She says herself, after jury selection started, I guess I should have researched the defense of EED. But even though she chose to pursue this defense, which would resulted in the manslaughter instead of murder, she didn't even ask the jury to return a verdict of manslaughter instead of murder, ever. In her opening, she didn't. And even in closing, she told the jury murder or manslaughter. It doesn't matter. One is not better than the other. There can be no explanation, no strategy for these things. And finally, I just want to touch on the excessive sentence too. Well, Miss Wade's, this extremely rare condition, pseudocyesis, by definition caused her to believe she was pregnant, as well as experience every single physical symptom of pregnancy. And it affected everything in this case. And it should be considered in reducing her sentence, as well as the really powerful mitigation evidence here that consisted of her severe and parental neglect and abuse and violence at the hands of her partner. And I would ask for you to consider reducing the sentence for that reason.
Okay, thank you, counsel. Thank you both, counsel.
Thank you.
Walker versus City of New York.
Good
Counsel, you
afternoon.
may begin.
Thank you. Thank you, Your Honor. Good afternoon. May it please the court, Hannah Sorokin for the City of New York. Your Honor, Supreme Court erred here in determining that the petitioner was a tenured employee and that she was entitled to a pre-termination hearing under the civil service law. Really, the plain language of the civil service law.
Counsel, I have a question. We know what the civil service law does say, but what do we make of your September 20th, 2023 memorandum to Ms. Walker that says otherwise? And does she not have the right to rely on that memo that you sent to her, telling her about her promotion?
So that letter is relevant to the probationary period.
Right.
As we addressed it's a separate issue from the civil service law. The letter doesn't entitle her to the civil service law protections. So they're really two different inquiries here, and really the Supreme Court erred under either one. But the civil service law is separate in that even if she were a tenured employee, even if DOC was bound, if the city was bound by that representation that the probationary period was only 3 months,
right.
She still would not be entitled to a pre-termination hearing under civil service law, because the plain language there, which really decides this case, is clear. A non-competitive class employee, which petitioner here concedes she was, is only entitled to a pre-termination hearing when they have 5 continuous years of service. And it's undisputed here that she doesn't. She was with DOC for less than a year. Counsel,
Did you make this argument before the Supreme Court?
So we did preserve it in our answer. It's the first affirmative defense. We say that she's not entitled to civil service law, the due process under Section 35 of the civil service law. It's not in the briefing. The briefing here really focused, and as petitioner did, on the probationary issue. But this court has held that a purely legal argument, clear on the face of the record and preserved in the defendant's answer, as is the case here, is properly before this court for review. But even if it was unpreserved, this is sort of exactly the type of situation where this court would be able to reach an unpreserved issue, because it's a pure legal question, turns on the plain language of the civil service law,
It's apparent on the face of the record and could not have been avoided. It's determinative here. So it is preserved, but even if it wasn't, this court could reach it in these circumstances. And really, the petitioner here offered no response to this argument. She hasn't disputed it, she hasn't challenged it, or even really acknowledged it in any way. So the civil service law really carries the day. If I may just briefly, the even if we were to get into the probationary period, which we don't need to, but even if we were, the error in that September letter, the city can't be stopped from correcting that error when the personnel rules and regulations here are clear that the probationary period for a non-competitive class employee is 6 months, not 3. Thank you, Your Honors. We ask this court to reverse.
Thank you.
For the respondent appellant, Jeffrey Kreisberg, Your Honors, the court below properly determined that the Department of Correction was bound by its September 2023 memorandum to the petitioner stating
Counsel,
that.
do you want to address the civil service law that indicates that she needed to have been an employee for 5 consecutive years?
Under Section 75, that's correct. However, once she became a permanent employee, her legal status changed from when she was a probationary employee. And so,
but did it change from competitive to non-competitive?
No. She remained a non-competitive employee. So what I'm saying is, counsel's correct that my client was not entitled to the full panoply of Section 75 rights, but she was entitled as a permanent non-competitive employee to due process before she was summarily discharged.
And that included a hearing?
It included a right to confront the accusations against her. It included a right to present material.
So counsel,
to the...
can I stop you, counsel? I have a
Sure.
question. Where is that located in the law? So we have the 2 types of issues. We have the probationary period, whether it's 3 months or 6 months. Let's assume it's 3 months. Under Civil Service Law 75, you get a predetermination hearing when you have 5 years. So where are the rights other than the predetermination hearing? What other rights would you have that would provide relief for your client? Where is it in the law?
Absent my client being afforded some due process rights once she completed her probationary period, there would be no difference between her probationary status and her permanent status. So what I'm saying is,
isn't that, counsel, isn't that what the collective bargaining agreement says, right?
Well,
she bargains away some things and she gets some things under the collective bargaining agreement. There's nothing unusual or weird about that.
The collective bargaining agreement is a separate source of legal rights. But what I'm saying here is, as a permanent employee, she had some due process rights to prohibit her from being summarily discharged.
And what case do you have to support that?
There isn't a case that I can refer to, but it's inherent in her status as a permanent non-probationary employee. If she doesn't, without that, then there's no difference between her status as a probationary employee.
Well, there might be other differences besides that.
Well, there's no
more vacation time. There might be plenty of other differences.
Well, in terms of job tenure, there would be no difference. In terms of job protection,
but that's just one piece of her entire employment panoply of rights, right?
But it's an important one. It's a very important one. And to
Counsel, quick question for you. Does it matter the basis for her termination? What panoply of rights are triggered?
Well, if she was discharged for reasons which she was told by the person who presented her with the letter of termination that were never investigated, because she was considered by the agency to be a probationary employee. So it matters from the standpoint of an employee having an opportunity to know why she was discharged, and to have an opportunity, if she's a permanent employee, to at
Well,
least
did they,
respond.
counsel, did they not advise her that there were still images of her passing contraband to a person that was incarcerated?
She was not informed that that was the reason for her discharge. She found that out later from independent analysis she did, but she was never informed by the department that was the reason for her termination. She was never given any reason for her termination. She was just summarily
So, counsel,
terminated.
are you saying that the statute is unconstitutional? Because
No.
the statute says you don't get a hearing until 5 years, regardless. If you're
it says you don't-
non-competitive, then you don't get a hearing.
It says you
till
don't get a
5 years,
hearing under
regardless.
Section 75, but that doesn't mean that you don't have due process rights as a permanent employee. And she did. She was a permanent employee at the time she was suspended without pay. She was a permanent employee at the time she was terminated without notice, without an opportunity to be heard, and that was unlawful.
Okay, thank you.
Thank you.
I guess you have 2 minutes on reply.
Thank you, Your Honor. Just at the outset, none of these arguments were made in response to our brief. The petitioner didn't mention
I
civil
didn't
service
see
law.
a due process argument. Okay.
The civil
What do you
service law
say
is
to that, though? What do you say to the fact that there's got to be something there, that she has to have some right?
But I think, as Your Honor noticed, there can be, several other privileges, rights that come with tenure here. But as counsel, again, petitioner has not pointed to any basis in law, in the CSL.
She might
and
get
the
2
PRR.
more weeks of vacation when she becomes a permanent employee. She might get other rights other than the right to a hearing on termination, right? That might be what the difference between being a probationary and so
Exactly.
that doesn't necessarily, becoming a permanent employee in a non-competitive status doesn't necessarily mean that you get a full-blown hearing, right?
Correct. And the Supreme Court's decision here was based explicitly on Civil Service Law 75. Supreme Court erred in determining that the petitioner here was entitled to a hearing when there's no basis in the Civil Service Law for that. And the personnel rules and regulations, PRR 1, expressly states that nothing in the PRR usurps the Civil Service Law. So again, that there's the petitioners pointed to no basis here for an entitlement to a hearing, which was the basis for Supreme Court's decision, and therefore we ask this court to reverse if there are no further questions.
Okay, thank you, counsel.
Thank you, Your Honors.
Let's see, Rothman versus Rothman.
Good afternoon. This is Nehemiah Glantz for defendant appellant Alan Rothman. This case is about finality, and it's not about what the plaintiffs argue is immunity. Defendants are not arguing that defendant is somehow immune from gender-motivated violence act or domestic violence. It's the opposite. The plaintiff has sued the defendant now 3 times. First in 2016 in the Nassau matrimonial, then in 2019.
Well, counsel, let's talk about the matrimonial. The matrimonial action was about dividing assets and no longer being married, right?
But it's not just that. It was more than that, because DRL 236B6 and B5, one for equitable distribution, one for the maintenance, they both compel certain findings. And one of those central findings is domestic violence.
Well,
And
it takes it into account as a factor for the equitable distribution, for dissolving the marriage, right?
this wasn't just a factor. This was almost a central part of her matrimonial litigation. And the court repeatedly, in that 37-page decision, repeatedly says that that it's awarding certain items of maintenance because of the domestic violence. It's awarding certain items of the equitable distribution because of the domestic violence.
Was that case, counsel, I have a question. Was there anything about the matrimonial ever heard by the second department?
Yes. In fact, the fact that the second department affirmed the lower court in Nassau County, that strengthens defendant's position in our case. That means that not only did the lower court in Nassau County adjudicate the same issues that the plaintiff
What was
wants
the
to
second? What
adjudicate
did
in
the
this
second
case,
department?
they were
What
affirmed
did
by the appellate.
counsel? What did the second department say about the medical expenses and other abuse-related losses?
It actually increased the maintenance from a 5-year period. It added another 7 years. It added another $600,000. She now gets just on maintenance, $1.35 million.
Well, that's because they were married for a long time. Wasn't that the basis of the second department's determination?
Yes, but also the determination was also because of the domestic violence. That was the
Did the second department affirm a denial of medical expenses and other abuse-related losses? That's one question. And then my second question is, how does your argument hold water in light of the Chen case out of the Court of Appeals, where these personal injury tort claims are different than what is sought in a matrimonial, as my colleague pointed out, which is a dissolution of a marital relationship and equitable distribution?
If I can go to the Shen case first, because it's very puzzling that the lower court, it referenced Shen several times. They even quoted Shen, but there's a portion in Chen that the court didn't quote, and the court didn't differentiate Chen. What happened in Chen was that there was a severe domestic violent assault in May of 2001. I think 6 months later, in September of 2001, they started the divorce action. Now, in order to get the divorce action over quickly, they stipulated that they would withdraw all the fault allegations except for one. And one of the fault allegations that they withdrew was this assault that happened in May of 2001. So the assault was never litigated in the matrimonial action in Chen. It was never discussed. It was completely new. And in fact, Chen itself, the very last 2 sentences in Chen, if I could just read it out, it's so important. First of all, it says, although personal injury claim could have been litigated with the matrimonial actions, as the facts arose from the same transaction or series of events, it was not. Why? Because it says, quote, all of Shen's fault allegations were withdrawn by stipulation. Then, I'm just skipping a couple sentences now, just the last 2 sentences in the decision. That's the portion that really decides this case. Quote, if a separate interspousal tort action is contemplated, however, or has been commenced, the better practice will be to include a reservation of rights in the judgment of divorce. Finally, if fault allegations are actually litigated in a matrimonial action, res judicata or some form of issue preclusion would bar a subsequent action in tort based on the same allegations. And I submit that there was no reservation of rights in this Nassau matrimonial action. She litigated all of her assault allegations, her domestic violence allegations. In fact, she commenced an action in 2019.
What, can
Just-
I just stop? May I just actually, you say she litigated all of her allegations. How did she litigate it? Was there discovery relating to the domestic violence incidents? Because in reading the second department's decision where they increased the amount of maintenance for the additional 8 years, they base it on lots of factors, and that's only like one of 8 factors. So it doesn't sound like they were litigating this to any extent. So to, you know, to make it rise to the level of res judicata or collateral estoppel.
First of all, the
And then I
second
would just
department-
add to that, would this tort claim entitle her to a jury trial? And did she get that? And do you get that in the matrimonial part?
First of all, the res judicata transactional theory and the issue and the collateral estoppel, it doesn't depend on the label that you put on the cause of action. If the issues of domestic violence, if assault was litigated and adjudicated, it doesn't matter that you put a different label on it, and it doesn't matter that you put a different label on the damages. And I can quote the cases, O'Brien, the 1981 case, that says, once a claim is brought to a final conclusion, all other claims arising out of the same transaction or series of transactions are barred. This is the kicker, even if based upon different theories or if seeking a different remedy. And I can quote another couple Court of Appeals cases that say exactly the same thing. There's
Okay, counsel.
Ryan.
Counsel?
Yes.
But you're sort of way over your time now. Okay.
I just wanted to say that the second department in the decision does mention the domestic violence
They did
as a factor.
Yes.
We saw that
Okay.
of one of many.
All right. Counsel?
Yes, Your Honors, thank you. May it please the court. I hope everybody's safe in this weather. I just wanted to touch upon something that Judge Michael said earlier is that when the court in the matrimonial proceeding was considering the domestic abuse and some of the medical treatment, it was but one factor in the distribution of the marital assets and the maintenance award. In fact, if you look at the record 185 to 190, the lawyer for Ms. Rothman in the divorce proceeding said, you know, domestic violence is but one factor when considering an award for maintenance. And that's all that was considered. It was not argued in the context of the GMVD, domestic violence, that act, or in the context of personal injury and or pain and suffering. That was not argued. And in fact, the records submitted in support of the maintenance awards that Ms. Rothman submitted consisted primarily of her medical bills and I think an operative report. And that's it. And we know in a personal injury case, which is held before a jury and not a judge, which the Court of Appeals pointed out in Chen as one of the distinctions between a personal injury case and a divorce proceeding. You know, we consider medical experts to determine what pain and suffering is or future pain and suffering. I'm on top of all the medical records.
So
that
then,
get
counsel,
admitted.
is it your position that no domestic violence could ever be fully litigated in a matrimonial divorce, in a divorce? Because all of these things that you're saying, you're just maybe having this bright line, right? But in a case where such as this, where there's been consideration and is made reference to in the order that domestic violence occurred and things like that, why can't we say that that had a full opportunity to be litigated?
The Court of Appeals says that you are not to do that actually, because of the differences between personal injury and divorce proceeding. They said, in fact, that argument was considered by the Appellate Division and the trial court. They both held in Chen, which was reversed by the Court of Appeals, that the plaintiff had a full and fair opportunity to litigate her claims of personal injury in that proceeding. But the Court of Appeals said, we're not doing that here because of the differences I enunciated before. In fact, the factors they considered is a divorce proceeding is handled by a judge, not a jury. That's one of the factors that are different.
And the damages, right? In a personal injury action, you would get damages with respect to pain and suffering. So the perpetrator would have to pay the victim. And in this case, all that's being happening is there's a division of assets between the two parties. So you wouldn't be able to get those kind of damages in the context of a matrimonial action, because essentially you'd be taking out of your own pocket to, because all the assets are marital. And if the husband has to pay pain and suffering out of, and has no personal assets, if they're all, then you couldn't even get those kind of damages, right?
That's correct. And also in the divorce proceeding, um, the analysis of the domestic abuse and the medical records was considered in the context of one, her ability to work.
Right.
That was really it. So it
I mean,
wasn't.
if you look, I was just going to say, to follow up with that, when I was speaking to your colleague on the other side, I was referencing the Appellate Division Second Department decision, which reversed. They reversed to give an additional number of years of maintenance, but they said that they were taking into account a lot of different things. I mean, there were at least 8 or 9 factors. This was only one of them. They didn't really consider the types of damages, and he said, and counsel said, well, it's, you know, you could call it whatever you want, but it seems to me that in an action as of the type that you have now brought, there will be very different kinds of discovery and very different types of awards and very different types of damages that just can't easily fit into the parameters of a matrimonial decision.
100%. And I think that's exactly what Chen held. That's exactly what the Court of Appeals was saying when they were discussing the differences between a matrimonial proceeding and divorce proceeding. One of the things another thing is the fee arrangement, which they pointed out that in personal injury, when you're doing that, it's a contingency fee arrangement. So you're not going to condition a divorce award on, oh, I got you a successful divorce. And then the condition.
Counsel, I have a question. You heard the Court of Appeals, they talked about a reservation of rights. Did you at any point in time saying we're dealing with equitable distribution, maintenance, and we're going to set aside the GMVA claim, or make it clear that we're only addressing the marital assets and any criteria related to that?
There's no indication of that reservation of rights, but I will point out that numerous decisions, I mean, in this, the court, I'm sure, has held, oftentimes there's a recommendation for a better practice, but that's not dispositive. The fact that you don't put a reservation of rights in there, the Court of Appeals isn't saying that's dispositive. They're just saying you're better off
Counsel,
doing
let
it.
me interrupt. Did you say anything? Let's not call it a reservation right. Did you say anything to the trial court to say that we have this cause of action and we're not reserving it, but we're only litigating this, but not that? Let's not call it a reservation of rights.
Well, that can be gleaned clearly in all the papers that we're only submitting these medical records, for example, because we want maintenance fees. Or I'm sorry, the lawyer that's representing my client in the previous proceeding specified in the briefs before the court, hey, these are the records, these are some of the invoices that show that she can't work. So in that, you can glean that that's what I'm limiting my claims to. Had she said anything about, she didn't say anything about pain and suffering or anything of that nature. So, and unfortunately, it was not a specific reservation of rights, like I said earlier.
Okay, all right, counsel,
And-
thank
and-
you. And counsel, you have 1 minute on reply.
I think the court is, I understand the court is focusing on the Second Department decision, but it's the lower court's decision that established the entire award in the first place. And if you look in the lower court's decision, they mentioned several times that domestic violence was one of the main issues that drove the award, and I can point it out.
Yeah, but only in the context of whether what her distributive award was going to be. So for example, if I get hurt in a car accident and I say I can't work for 2 years, the car accident is relevant to whether or not I'm going to be able to work for 2 years and I should get maintenance for 2 years, but nobody's going to say I can't sue the driver of the car for the car accident.
Understood, but if the driver is the husband, and you're using that as a factor to get a higher maintenance, which she did. She got a very favorable maintenance award. She got a very favorable equitable distribution award. She got a very favorable credit.
So counsel, let me ask you a
all
question. Did
because
she
of the
get,
domestic
counsel,
violence.
did she get pain and suffering and punitive damages that she's requesting here?
She doesn't have to get punitive. It's not the label that counts the punitive damages. The label doesn't
And how about
count.
pain and
It's
suffering? Is
the
that
pain.
accounted in the order of
It is.
of
It
the
is. The pain
matrimonial
and
court?
suffering, it is included. The court mentioned several times the pain and suffering that she suffered, and I can point
No,
it
no.
out.
Is there an award of pain and suffering as a judgment in this
Second
case?
element.
It doesn't have to be. That's not what. That's not what a collateral estoppel or issue or transactional requires.
And then you can argue whether or not, first why don't you answer whether there was, and then you can tell us why you don't think it's important. But clearly, I think we all realize there's no pain and suffering award here.
I think that there was a pain and suffering award. The court references several times how the injuries made her unable to work in the past and unable to work in the future. Repeatedly,
Okay.
I can point it out to you, all the pain and suffering that the court referenced. All the shoulder surgeries that she had. Repeatedly. She had 6 surgeries, I understand, because of this.
Yes. Okay. Counsel, thank you both very much.
Thank you very
Thank
much.
you. Thank you.
People versus Esteban Villamon Almonte.
Good afternoon, Your Honors. David Clem for Appellant, Mr. Esteban Villamon Almonte. The court shouldn't have denied Mr. Villamon Almonte's application for plea withdrawal without any inquiry. The plea colloquy here was certainly no model colloquy. It was, as the court noted, a dramatically different offer and a brand new offer that was made on the day of the plea. Mr. Villamon Almonte twice requested more time to consider that offer, and it wasn't just the length of time, of course, it was the very serious immigration
So
consequences.
counsel, I have a question. Isn't there case law saying that time factor simply is not enough to make out coercion as a matter of law?
We're looking at a whole variety of factors. There's no one that may be dispositive, but we look at everything that's there. And what we also have, besides just the failure to grant any adjournment, we have counsel, of course, taking a position adverse to his client, but he's the one instructing Mr. Villamon Almonte that there's not going to be an adjournment. We have dangling over Mr. Villamon Almonte's head this idea that he's facing a 92-year sentence, and that if he doesn't take the 4-year offer now, he's going to trial and there'll never be another opportunity for it again. And then we have this very disturbing, completely unexplained colloquy about someone instructing Mr. Villamon Almonte to just say yes or no to everything during the colloquy. You know, we couple that with what we see in Mr. Villamon Almonte's papers, which are very specific assertions that
I have a question. Just in terms of that, just say yes or no statement. The court inquired as to who said that. There's no indication as to where that came from in the record. Is there?
the court didn't, I mean, the court in part inquired.
Because the interpreter answered, the interpreter heard it, but we don't know where that came from. Is that correct?
That's right.
And saying just say yes or no, I mean, it is different from telling someone just to say yes to everything. Can we agree with that?
In this context, I'm not quite sure that it is. What the instruction really is telling Mr. Villamon Almonte to stop adding what he kept adding, which was all his concerns, which was when he was asked, "Are you happy with your attorney?" He said, "Well, I didn't really get advice." And we see the more specific allegations in Mr. Villamon Almonte's affirmation in support of the motion to withdraw the plea, some that are really disturbing. Counsel never visited him. Counsel didn't speak Spanish, never used an interpreter in his conversations with him. There were no letters. He was never available for calls except for the few times they spoke. Defense counsel was in a rush and didn't have time to speak. All of that just required additional follow-up by the court. It just couldn't be denied without any inquiry here. There was a timely motion to withdraw the plea. As my adversary concedes, the appeal waiver has no applicability to this claim. There should have been an inquiry. These were serious allegations that were preserved and made timely to the court in the context of a plea that we shouldn't be terribly comfortable with and with very specific allegations. Thank you.
And thank you, counsel.
Thank you, Your Honors. May it please the court, Robert Juman for the Attorney General and the people as respondent. Your Honor, defendant's coercion claim is unpreserved, and there are no exceptions that apply here. The only claims that are preserved that I think my opponent was referring to are what the defendant actually referred to below, which was a failure to give immigration advice, a failure to advise his potential defenses, and the right to testify in the grand jury. Those may have been preserved. A claim that he was coerced by the court's comments or by anything his attorney did or by this just say yes or no, that wasn't referenced anywhere in his withdrawal motion.
There was a 440 motion, right?
There
Was
were
that
no
raised?
440. There were two
There
motions
was
to
no
withdraw.
440? I'm
Two-
sorry,
two-
right.
Yeah,
That's
two
what I'm
motions
saying,
to
they were-
withdraw, and in each of them, there's the only hook they have. They put a tremendous amount of weight on this phrase, a reference to pressure in the two motions to withdraw. It does not support the weight that the defendant places on it. This is a factual assertion that the defendant felt pressure, but that assertion of fact is made by Gonzalez, an attorney who wasn't present, had no personal knowledge. The defendant, who had personal knowledge, did not put that into his affidavit, didn't say anything about feeling pressure of any kind, let alone from the court's comments or from the plea deadline or from this just say yes or no to everything. There's no elaboration in either of his motions. There was no 440, and there's no discussion in the memorandum of law about any of these claims. And under the defendant's theory, this reference to pressure would literally preserve any conceivable pressure claim, such as that the defense attorney threatened the defendant's family or the judge bribed the defendant with $10,000 in cash. It simply can't support that weight. At any time, the defendant could have submitted an affidavit referencing the plea deadline, the court's comments, or just say yes or no. He never did, and so it's non-preserved. The court should not exercise its discretion to review because there's been no justification for failing to preserve those arguments, and the claims are meritless. And our papers go through each of them. I won't belabor the point given the limited time, but the bottom line is that coercion requires some threatened negative consequence if you don't plead guilty, and the defendant doesn't identify any such consequence other than going to trial, which is what every defendant faces. And there's nothing to be gained by further inquiry here. All the relevant facts are contained in the record, in the plea colloquy, which we already have. And just to be clear, there's no basis for inquiry on the coercion claim, which is unpreserved, or the Padilla claim, which is preserved, but is grossly meritless. The court bent over backwards to make a clear record. The court was acutely aware that frivolous Padilla claims are made by defendants, and so he made sure that the record showed, and the defendant agreed, he had been advised by his attorney of the immigration consequences. The attorney put that advice on the record, and the defendant agreed he had been advised by his attorney. So for all of those reasons, Your Honor, we ask that you affirm the convictions.
Okay, thank you. Counsel, you have 1 minute.
The issue is fully preserved. I mean, I'll quote directly from Mr. Villamon Almonte's affidavit here. My understanding of the English language is extremely limited. I was not able at any point to constructively communicate with my attorney as a result of the time limitations and language limitations. I was
Well, how
fully
does that mean coercion?
Let me continue on more. I was fully unprepared and had not in fact discussed any issues of my plea other than that if I failed to accept the plea that I would go to jail for a very, very long time. That combination.
Well, how does that mean that I was coerced? That's just a statement. If he was convicted, he was like, it was a 19 or some great count indictment, right? So how is that conversion? How does that preserve the claim that he was coerced?
He's saying he never had an opportunity to speak to his lawyer because they
That
didn't
sounds like
even
a
speak
440 to me.
the same language. It's set out here as the facts. It was a timely made application for plea withdrawal. If a hearing was necessary, it should have been granted and should now be sent back for one. There's no additional facts that are needed. Thank you.
Thank you. Thank you. Okay,
Thank
so
you.
now we're gonna say good night to Judge Michael, and we're gonna have our last oral argument on PH 105 Realty versus Munzer Alliance. All right, let me just. Okay, Counsel, you can begin.
Okay, Your Honor. May it please the court. It's been interesting sitting here all afternoon listening to these cases. My hat's off to you. I always learn things. You know, I wouldn't be honest if I didn't say I enjoyed some of it. But this case is a lot more straightforward in the sense that, Your Honors, the First Department has already dealt with this issue. And it has to do with tax estoppel, and you all are very familiar with it. And our case had two claims. One claim for declaratory judgment, which the jury unanimously returned in favor of the plaintiff, and another claim for unjust enrichment. And we respectfully submit that the trial judge, who was a tremendously competent, conscientious, and on-it judge, had a very hard case. I think made a lot of balls and strikes, calls, did so admirably, but we respectfully submit that there was some reversible error there. In that he did not grant a judgment in favor of the plaintiff on the unjust enrichment claim. And I'll just unpack that very briefly. Essentially, the jury found that the plaintiff was a 75% owner of Edgewater. There was uncontradicted testimony that defendant LAN exercised domain and control over the property.
I have a question, Counsel.
Yes, Your
In
Honor.
terms of loss, something that the plaintiff lost, was there any out-of-pocket loss for him? Like, or what did he pay out of pocket?
So the loss during the time that defendant LAN was exercising the property was the ability to use that property for himself and for his own services. And by contrast, Your Honor, defendant LAN, there was testimony and evidence that he used the property for his own storage, that he was making $9,000 a month renting that property. So it's essentially the lost value of exercising.
Did the plaintiff pay the carrying costs and the property taxes as well?
He did pay some of them initially, but while defendant LAN was in control of the property, he paid some as well. But at the end of the day, Your Honor.
Counsel, isn't it undisputed? Isn't the undisputed testimony that the property was carrying at a loss the entire time? What did your client put in to show that it would have been anything but the loss that the testimony showed it was?
Well, in terms of the testimony, Your Honor, it was operating under a loss, but it was only operating under a loss because defendant LAN was operating it under a loss. Had my client been able to operate and use his
Again,
property.
what did you put in to show what your client would have made if he had the use of the property?
I think the record is not entirely clear on that, Your Honor.
Well, I mean,
Okay,
I think that, I mean, that's probably at least part, I mean, not hard for me to say why the jury decided what they decided, but they heard all of this, right? They heard all of these things. I mean, that was one of the issues that was left open by the prior decision of the appellate division was the unjust enrichment claim. They heard the testimony and all this conflicting stuff we've been talking about and just must have felt it was a wash or whatever, that you just did not prove by a preponderance of the evidence to the jury in that case that, you know, that you were entitled to anything. And that's why the jury came out that way. It's very hard to set it aside and say that there was no reasonable way that the jury could have come up with that conclusion on that cause of action.
I understand, Your Honor, and your point's well taken. I think, like I said, this was a very difficult case. It did come down to credibility. It came down to a lot of things that the jury had to weigh, and they
Right.
did. So I certainly appreciate that. I will note that we did have an expert testify to the value of the property, and essentially we asked that the jury award the plaintiff or percentage of that value for him being deprived of it. Just a few other points, Your Honors, if you'll bear with me. I hope I'm not coming close to my time, but I don't have much more. Some of the things that the court permitted, it's in our brief, evidence-wise, I think undermine the unjust enrichment claim, including permitting the defendant to violate the tax estoppel doctrine and make arguments against that. And then finally, Your Honors, the court should have permitted the jury to consider punitive damages in this case. I mean, we had a situation in which the defendant, who was a sophisticated developer, sought to take advantage of his younger cousin, deprived him of his property, and then through many machinations and fraud, conceal that and continue to conceal that. And one of the reasons why the tax estoppel was so important here is because the defendant gave the plaintiff these filed tax documents to show ownership when the plaintiff asked for it. So,
But the thing is, the tax estoppel issue came up on a prior decision here, you know, the 2020 decision in our court, and we said that the court had improvidently exercised its discretion, failing to apply it, and we did apply it. We said that that was important, and in the end, you were found to own 75% of this property up through now. So, I mean, you won a lot of things. You just didn't get this unjust enrichment, you know, this unjust enrichment claim, but you got the other thing. So I don't know.
well, my
Look, I
argument
know
is
you
here,
wish you
Your
won
Honor.
everything. I get that, but
No,
but
that's fair, Your Honor. And if I just may crystallize this last point, what I'm saying in my last point is that there was error here just on damages, in the sense that the trial court did not let the jury consider punitive damages. And we respectfully submit that
I
the
mean,
trial court should
generally
have left that.
punitive damages are for situations that go to the public generally, not private disputes, right? Okay. Thank you
Your
very
Honors.
much. Counsel, you want to respond?
Thank you. Good afternoon. May it please the court. I'm James Smith from McCool Smith on behalf of respondent and cross appellant Munzer Elian. I'll first address the points that Mr. Bushi raised with his client's appeal, and then I'll briefly address our cross appeal. As you're well aware, the jury found that there was no adjustment and enrichment in this case. That verdict should be upheld for at least two basic reasons. I'll try and address everything Mr. Bushi said. The first reason is that one of the bases of the appeal, this issue, in fact, I think the primary basis is that the tax estoppel doctrine somehow should have been applied with regard to the unjust enrichment claim, and that Justice Frank erred in allowing us to put on evidence that the plaintiff in this case didn't pay any money towards the property. But that rests on a fundamental, on a false predicate. All right. The tax returns at issue here didn't actually say that Mr. Jabber contributed any money to the property. In fact, they said that he did not. There is a line for capital contributions. That line is blank. It said he didn't contribute money to the property. And just so we're clear on this, it's in the record at 385, 413, 452, 481, and 514.
I have a question. Was there any
Yes.
testimony that Munzer collected $9,000 in rent?
No, Your Honor. There was not any testimony on that. And I can address that point. Skipping ahead, I mean, set aside the tax estoppel doctrine, there's no, the plaintiff in this case didn't come close to putting in evidence on any of the elements of unjust enrichment. Your Honor hit on the first element, the enrichment. Here, there was no enrichment of the defendant. As I believe Justice Kapnick recognized, this property took a loss over the years. Mr. Elian himself testified the property didn't make any income. This was corroborated by the tax returns that plaintiff relied on in all other aspects that showed the property made zero money. This was corroborated by their appraisal expert, who testified himself, there were no documents, there was no evidence that he saw that indicated the property made any. What appellant's argument is based on are a set of invoices that were excluded from evidence that purport to show there was something like $9,000 a month in rental income on this property. But that fails to carry the day as well for two reasons. I mean, first, they were properly excluded, right? There was no authentication. They were hearsay. They weren't business records. Put that to the side. Even if they were admitted, they actually didn't show that the property made any money. They showed a balance due that accumulated with each month as it went by. So you have invoices in the record at 3058 to 3077, dated from January 2010 to August 2011, that reflect the balance due increasing from $9,000 to $180,000 after that roughly 18-month period had passed. So even if those invoices had been admitted into evidence, Your Honors, they don't support the notion that Mr. Elion was enriched or received any income from the property. Last point on this before I move on, I just want to make sure it's clear. There is absolutely no evidence in the record that Mr. Farhood Jabber put in a penny of his own money towards the property. I asked him again and again, did you personally fund the purchase? No. Did you ever pay its carrying costs? No. You didn't pay any taxes? No. This was corroborated not just by the defendant. This wasn't a he said, she said. This was an everyone said. His brother said it. Their friend, Vadim Brodsky, who they got to testify, he said it too. We were all in agreement. He didn't put any of his own money into the property. And so the jury was entitled to credit that evidence and find against the unjust enrichment claim. Briefly, with regard to punitive damages, there is no case law saying that punitive damages are available for an unjust enrichment claim. Appellant doesn't cite any law to the contrary. And as this court just recognized, this was at its worst, believing everything plaintiff said, which we obviously disagree with. At its worst, it was a private dispute, a quintessential family dispute that didn't impact the public at large. So, I mean, there's just no call for punitive damages here. If I could briefly turn to our—
Okay, why don't you start with your cross appeal now?
Right,
And I'll give you your time on the cross appeal.
Thank you. I will be brief. The jury had two findings here that we take issue with. The first is that it found that Mr. Farhood Jabber was 75% owner of Edgewater. That should be overturned for a number of reasons. We put them all in our brief. I want to focus just on two here today. The first is that it lies contrary to New York law on corporate ownership, right? In order to establish ownership of a corporation, that the plaintiff has to put in evidence, establish that they paid some sort of consideration for that ownership, for those membership shares. That's from First Department law. It's from Court of Appeals law.
So that's where the tax estoppel issue comes in, right?
Well,
so you have a tax estoppel. You're stopped from denying, based on your tax documents, that at least in 2014, he was an owner of the property. That's what we said. That's what's clear. So what evidence did you put in from 2015 forward to show that he sold or gave back or did anything with respect to his interest in the property?
Sure. So I'll answer that in a couple ways, Your Honor. I mean, first, separately, and I can address it. It sounds like you don't want to hear it, but we took issue with
because we're pretty
the application.
We're pretty clear about this tax estoppel. So
Sure,
I hardly doubt that we're going to go back and change our mind on something that we ruled on before. So let's assume that we say in 2014 he had an interest in the property. Again, I ask you, what did you put in to show that he divested himself of that interest after 2015?
Sure. So assuming that that Mr. Jabber was the owner in 2014, the evidence of Mr. Elion's ownership
that's what you represented. We're not assuming it. That's what you represented to the taxing authorities. So then in 2015 forward.
Since then, Mr. Elion continued to pay every cent, take on every obligation that was associated with that property. his name was on all the
Wouldn't
papers.
you need
That
to
is-
show something more? Wouldn't you need to show something more than that at this point? Because if we have already, as my colleague has said, and our decision says, up to 2014, plaintiff had a 75% interest. How did he lose that?
He lost it. Well, one, we take issue with that because we
You
believe it
can't
flips
take
the
issue with
burden.
it. It's done.
Okay.
Move
No,
on.
and not just that, it flips the burden of proof at trial, which we do take issue with. But the evidence we put in, Your Honors, was that Mr. Jabber in 2014, that was when the property became embroiled in litigation, and he went to my client, Mr. Elion, and asked him to take his name off the property, take him off the tax returns, because he was afraid of incurring, actually paying some money that had to do with the property. That's at the record in page 2052 to 2053. That is the evidence there.
Well, you
And
know, but
frankly,
there,
it's-
from what I can tell, and I didn't read every word of the trial testimony, but what I can tell that there was someone else, Mr. Brodsky, who was referred to before, who testified. He owns apparently undisputably 25% of Edgewater. He testified that Jabbar never asked to be removed as an owner. Your client testified differently. So the jury had to, sit there and figure out who they were going to credit. And unfortunately for you, they credited the other side on that finding. They credited you on the unjust enrichment. They credited him on that. So how do we set that aside? What's wrong about that?
Sure, you can set it aside because it's not, again, that's an area of he said, she said. But we do have the weight of the evidence on our side, not just one
What's
defendant
that?
saying one thing. The weight of the evidence is what is undisputed. Who acted as the owner this whole time? Who purported to be the owner?
Well, you
who
could
paid
act as,
every cent.
can't you just act as what you want? I mean, don't you need to have a piece of paper? You can't walk around New York City owning property and say, I own it. I could act like I own it, but if I don't have a piece of paper to prove it, I don't own it.
No, I mean, one of the elements or one of the considerations that courts look at, I'm thinking of the Pappas case from Kings County in 2009, says, how do other people perceive you? Who holds themselves out as acting on behalf of
Okay,
the
so
company? It's not
assuming
just a
that,
piece of
okay, so
paper.
all you're talking about is disputed testimony. Anything else besides disputed testimony? Any
Sure,
documents? Anything else?
There are documents, the fact that my client is on the operating agreement. He's named as the 100% member on the operating agreement. He's named as the 100% member on the shares. He's the only one undisputedly that put in capital, that made capital contributions to the company. That's required under the operating agreement. It's in the record at 164 as a provision required of its members. If someone's not going to put in capital to the company, they cannot be the owner. Setting aside the period in which tax estoppel applied, we are talking about the current owner, which that's what was for the jury to decide.
Once I'm an owner, I don't necessarily have to put in anything more. That's just not really right. Anyway, thank you. We'll have time to reply. Let me get the answer to the cross appeal. And I know you have a motion to intervene. That's coming last. So let me just hear the answer to the cross appeal.
Thank you, Your Honor, and I'll be very quick, since the panel has correctly dispensed with the tax estoppel issues or purported issues. So to answer the panel's question, which my colleague on the other side wouldn't, is what has LAN shown that my client gave up his 75% share? The answer is nothing, nothing. The plaintiff testified that never happened. Vadim Brodsky, the neutral 25% undisputed owner, testified that never happened. Jabber testified that never happened. And the jury was correct to reject the testimony of Mr. LAN and believe the three other witnesses. Additionally, when Mr. Smith says, oh, well, there was an operating agreement, there was this, there was that, all that predated the tax estoppel period. When LAN went to the federal, state, and local authorities and swore under oath that my client was the owner. In addition, those documents were to generously characterize it suspect because they were not produced during discovery. They were found apparently in a drawer post-discovery somewhere, and they all of a sudden appeared, and no one had ever seen them. And even Vadim Brodsky, who was an undisputed 25% owner, said, I'd never seen this operating agreement. There was none. I never received shares because there were no shares to give out. And all of these documents are hocus pocus. So at the end of the day, Mr. Elian stands where he currently is, which is without any evidence or proof that Farhud Jabber or Vadim Brodsky gave up their shares ever. And so I have just one last thing. When counsel says about, and I'll be very brief, Your Honor, when counsel says, oh, First Department case law, he's talking about the La Rosa case, which was a very specific First Department case that was interpreting an MOU between parties, and pursuant to the MOU between parties, one person had to make a capital contribution to be an owner. Obviously, we don't have that fact here. We have families disputing about a property and one took advantage of the other. So I'll rest it there and on my papers, and I thank the panel for its time and attention on this appeal.
Okay, and now I'm going to head towards the motion to intervene, the appeal from that.
Thank you, Your Honor. May it please the court. There really are three separate strains of interest here. One, and I'll go back to the 2020 decision, is the LLC interest versus the property interest. When this court decided in 2020 was that the defendants were stopped to deny a 75% ownership interest to 2010 to 2014 based on tax returns of the LLC. And it in fact indicated there was an issue that remained an issue of fact as to the owner who presently owns Edgewater, which can only mean the LLC. There's no question, right, wrong. I'm not here to defend Mr. Elian. I'm not here as to who owned the LLC interest necessarily. There is no question as to who was managing the LLC. This is admitted by the Jabbers, by Mr. Jabber. This is he had, if not actual, at very least apparent authority. And in long after he had notice of
So let's
tenancy
start
had
with
expired.
this. When did you move
Sure.
to intervene? When did you move?
We did not move to intervene until the verdict
After the
sheet.
trial.
Correct.
After
Very
all
simple.
the jury verdict and all of that, right?
Right.
When
Very
did you
simple
first
reason.
know? When did you first know that you would have, that you wanted to, that you were affected by this case?
We knew there was an effect in the sense that we knew there was a possible exposure for a voidable claim that our title was voidable, but there was no reasonable expectation. And I'm relying
I'm
on the
asking,
Faison
when
case.
did you know that?
Mm.
When did you know that?
Sometime around 2020. We understood.
So you waited until after you got a jury verdict to move to intervene.
The only exposure we had at that point, having purchased for consideration in good faith from the person with at least apparent authority to sell, was that there could be a subsequent attack on our title. We had no basis, and the court did not instruct the jury, apparently, on the difference between void and voidable title.
Well, there was a notice of pendency put on the property in 2016, right? So
and
you had
it
some
expired
notice
3 years.
that your interest in the property was going to be affected as early as 2016, right?
That expired 3 or more years before.
Okay, but we're talking about, did you have notice of the claim, and then did you wait until after the jury verdict, right? It's really a matter of whether it's untimely.
Yes, that was the narrow decision of the court that had to do with timing. And timing is an effect of expectation. if we had no expectation of a direct attack on our title, and we had none, it was only reasonable to see how things played out until they presented to the jury. And remember, we were not parties to this trial.
The jury, you can't wait until you get a jury verdict that negatively affects you and then decide to intervene. That's untimely. That's the epitome of untimely, right?
When that jury verdict is based on an error of law that should have been apparent to the court and was not raised, we had no way to see that coming.
Well, didn't you show up at some of the trial? I mean, that's what I understood. And how could you not think, that you could come in and say, I know exactly what the jury's going to do here, and this won't affect us. I mean, I think I'm hard pressed to accept that, having tried many jury trials in my career.
No, we were not monitoring the trial. And frankly, you
knew it was going
difference
on.
We knew it was going on. We knew that there was issues as to the ownership interest, because that is what this court sent back to the court below, the interest in the LLC. Based on that, we had every reason to believe that, having bought, good faith purchaser for value, that our interest could only be terminated, first of all, on our presence, second of all, on a proof that the title was somehow voidable. Remember, Munzer Alien had every right on paper, every proof that he had control of this company. We paid valuable consideration for it, and the law was very clear. Having done so, they would have to show either that either the title was procured by our client by defrauding the grantor, Mr. Alien, and that was never alleged, and there's no evidence of that, certainly, or that there was a forgery on the title.
We're just talking about intervention right now. We're not talking about proving the claim, right? Okay. Thank you very much, counsel. You have a couple of minutes to respond.
So they had noticed from as far back as 2020 that the title may have been implicated. They did nothing. And if that wasn't enough, and I'm going to primarily rest on my brief because I don't have enough time to go into all the willfully missed opportunity here. So 2020, they knew they didn't intervene. Then they were subject to an order to show cause in 2022, years before the trial. They showed up for the order to show cause. 3 attorneys entered the appearance on behalf of this entity. They argued. They even said in that opposition to the order to show cause, our title, our interest is affected here. They didn't intervene after that. Then they were subpoenaed for trial and some other documents. They didn't intervene then. And up and through trial, and we have the exact number in our brief, but the 3 attorneys that they had enter an appearance on behalf of this entity, which is a sham entity and a sham transaction, but the 3 attorneys that they had representing it all received the NYSIF notifications. I believe it was 250 notifications each from every docket entry. And that includes motions in limine, trial documents, trial subpoenas, everything else. The reason, and I hear some of the questions that my colleague, my learned colleague on the other side is getting. It's like, well, you didn't intervene, right? Yeah, it doesn't make sense because this whole transaction was nothing more than an insurance policy from LAN. He flipped this property for no consideration to his business partner. And there's evidence in the record.
But we're just talking about whether it was timely or untimely, right?
Okay, so in terms of timeliness, the reason why it doesn't make sense and they didn't act sooner is because this was all orchestrated by LAN as an insurance policy. So they had 3 attorneys in there. They had, and by the way, the people who consummated this transaction, the law firm was LAN's law firm, and it was the same attorney for both sides. So And it was the same title agent that Eliane uses and is the wife of the attorney who represents Eliane. So all of this goes to show is that not only did they have actual notice, they had constructive notice and willfully ignored it until there was an adverse verdict. 9 days of jury trial, fellow citizens inconvenienced to come into court. Judge, like I said earlier, did a very admirable job with a very tough case, numerous witnesses, experts, and here we are. The last thing I'll say about this is there's nothing to
Well, this is
intervene
it.
in.
You're only doing way over your time, so it has to be the last thing.
Okay, last thing I'll say is not only the incurable prejudice that would result from possible intervention, but there's nothing left to intervene in. The case is over. The jury's decided. What are you intervening in? Are we supposed to now go back and redo a 10-day jury trial or do something else? The proposed intervener's interests were adequately represented at trial in any event because the same documents that they rely on now were the same documents that Eliane presented at trial and the jury rejected. I know it's been a long day. Thank you all for your time and attention
Thank
to
you,
this.
thank you, counsel. Thank you all, counsel.
Thank you.
Do I have my 2 minutes? Or?
Oh, let me see. Did I give you okay, I'll
I
give you a
believe you
minute.
did.
I don't recall if I did or
Okay,
didn't, but I'll
I
give you
don't, yes.
one.
I
1
don't want to
minute.
keep you, yes. 2022 OSC did implicate our title. It commanded that our client reconvey, even though he was a non-party to the suit, reconvey to Mr. Jabber. It was rejected flatly as being well beyond anything they could prove, anything other than their allegations. Guilt by association, guilt by
No, I don't want to. I mean, we're
the
just
number of
talking about
attorneys then.
timeliness. The question is
Right,
whether
right.
do you have an obligation if you know about the lawsuit, if you think it may affect your interests, whether you have an obligation to move then to intervene, or can you wait till everybody spends 10 days of trial time, see what the verdict comes out to, and if you don't like it, then move to intervene. That's the question.
What-
I'm not talking about
when
all
the-
the rest of it is a sideshow.
But when the only answer that we could anticipate was that there would be some additional litigation, that we would have our due process rights notice and an opportunity to be heard, an opportunity to examine witnesses. There was no reference, no referee or rather receiver sought in this case. They didn't renew their notice of pendency. They had a determination from this court that this was about the LLC interest. And as I said, we were a good faith purchaser for value. That has not been disproven. The fact that the brother of one of the members of this LLC was a business associate of Mr. Eliane is irrelevant.
Okay.
Guilt by
All right.
association is not a legal term. Thank you.
Yes. Agreed. Okay.
And thank you for your patience
So,
all.
Good night, everyone. This
Good
is
night,
Good evening.
Thank you.
adjourned.
Have a good evening.
Thank you.